sorry that I did wrong.
Here's where we're at, Mr. Vanover. It's incumbent upon me to impose a just sentence in this case. And, you know, the knee-jerk reaction for these types of cases is to say, oh, you know, you should just add up the maximum penalty and impose the maximum penalty, and that's somehow justice, and it's not. And the reason for that is because it's an incumbent upon me to determine among the people who commit this offense and among the offenses that constitute this crime, what the appropriate sentence should be. It's complicated by the fact that the plea arrangement in this case took the maximum penalty from somewhere in the neighborhood of 19 years down to about 4.5 years. And, you know, I don't engage in plea negotiations, so, you know, I don't know what the back and forth was about people not wanting to testify or the risk that you may be found guilty versus not guilty, whatever. All of that makes it difficult for me to fashion appropriate sentence given the facts. I don't think that you take much accountability for this.
I do, Your Honor.
I don't think they do, Mr. Vanover. And I think that the tiers that you have are for you and not for them. So the court is going to impose a prison sentence in this case. On count 1, which is the GSI involving Celeste, I'm going to impose 18 months in prison. On count 2, for the assault on Lincoln, I am also going to impose 18 months in prison. And for count 3, which is the GSI on Ava, I'm going to impose 18 months in prison. This includes a mandatory period of post-release control. That means the adult parole authority is going to supervise you for a period of 5 years after your release. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. I'm going to give you credit for the 50 days that you have already done. You are required to register as a Tier 1 sex offender. I'm not going to impose a fine in the case, but I am going to impose the costs. Further, Mr. Vanover, I'm going to order that these sentences be served consecutively to one another. That means one after another, because a consecutive sentence is necessary to properly punish you, and your criminal history suggests it's necessary to protect the public, and no single sentence will adequately punish you for this. So that is a sentence of 54 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you without charge. Is there anything else we need to do? Anything I forgot?
No, Your Honor. Thank you.
Just Your Honor, as it relates to the consecutive sentencing, I believe that as it relates to the statements on the record, Your Honor, for purposes of the findings that must be made, I know that you indicated prior criminal history shows that consecutive sentences are appropriate, but I don't know that I heard any other.
I guess him being on probation, his probation is for an offense that's after that. So it wouldn't be his prior criminal history. So it would be that the subsection where no one prison sentence is appropriate for or will serve the interests of the public in protection and punishment.
Thank you for clarifying that, Your Honor. Okay.
All right.
Nothing further from defense.
All right. The hearing's over. The way this is going to work is everybody on this side of the courtroom is going to remain seated. Everybody on this side of the courtroom is going to exit out the back. We're going to do that now. Mr. Vanover is remanded to the custody of the county sheriff pending transport to the institution. Good luck to you, Mr. Vanover.
Okay.
You got one.
I need a card with all the information on it.
So are you wanting to take your wallet with some money with you? All right.
That, so he can have all that.
Okay. All right. Okay. You're gonna go with the deputy here.
Yeah. Just,
Yep.
all that stuff. I'm taking this with me.
All right. Can you walk about this? Okay.
Not right now.
What transpires?
Right over for the people. The people waiting any potential conflict of 15 years honorable court in the office of the public defender. The people do not believe such a conflict exists, so we may just make this waiver and we're going to slow down.
Thank you.
Your Honor, Assistant Public Defender Ben Benowith, the Public Defender's Office also waives any conflict between this honorable court and the Public Defender's Office.
All right. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided they're under. To the extent a conflict does exist, given the waivers, the court will consent to you. They all set point
Yes, they are.
there. Court does call the case of the people of the state of Michigan versus Denario Boynton.
And then on behalf of Your Honor.
Good morning, I'm Robert J. Kill on behalf of Mr. Boykin. Scenario, when you come to the podium, would you state your name?
Denario Boynton. Thank you. All right, what are we doing?
They have several preliminary examination. At this time, you are unable to proceed as to count one, but ask for count two to be waived to issue.
On behalf of my client, Judge, I would ask that count one be dismissed.
All right,
Court's going to remand it to district court. I'd like to make a bond argument.
certainly. Count one is dismissed. I'll continue to defendant's not guilty plea as to count two. Pretrial will be set
July 13th at 9 a.m.
July 13th, 2026, 9 a.m. before Judge Washington. Yes, Esteban.
Judge, I know you've heard this argument before, but again, my client is the father of 4 minors. Currently, his older daughter, 18-year-old, has been holding down the family. They all live in one apartment. The rent is overdue. My client is gainfully employed, grass cutting business. The victim in this matter is not the biological mom of any of the kids. There's no need to he be there. My client does not want her there. What we're asking the court is to release my client on a reasonable bond, Judge, hopefully PR, but if necessary, tether.
Your response.
Your Honor, at this point, I would object. If the court was going to be changing, I would ask that you change to the $5,000 cash surety, given the severity of the assault in this case. I would have concerns for the victim's safety. Present at the house.
But, okay. But she's not here, correct?
Correct.
And as I'm looking at the addresses, the International Drive is his address.
Yes.
Correct, Your Honor. I believe she's been staying there for a short period of time.
Do we know whether or not she's staying there now? No.
Just be careful. Judge, she's not.
Well, okay, but
Okay, I'm sorry.
I'm asking whether or not the people are aware that she's still staying there. The information defense has is that she's not there.
Yeah, she never lived there, Judge. She would stay there for several days or something to that, but other than
I
Honor.
get that, Mr. Killowalt, but I don't know what people's living arrangements are. I have his address in the file as the address that this occurred at. You're telling me she's not there. I was asking for verification from the people as to whether or not that's the case. That's what I need.
Judge, for what it's worth, she has her own separate address. And that's stated in,
Okay, so I was ready to roll. Do you want to keep talking?
no, Your Honor.
All right, what I'm gonna do is I am gonna reduce the defendant's bond given the circumstance. I'm gonna reduce his bond to a $25,000 personal recognizance bond. I will indicate that defendant prior to release is to be placed on a GPS location tracking device with the exclusion zone to be provided by the prosecutor's office for the alleged victim's address. Right. Thank you.
Thank you, Your Honor. That you was a text. Oh, okay. Call me when you get out.
So court does call the case People versus Christopher Johnson.
Yeah, this is on behalf of the people, Your Honor. I mean, it's silly.
Mr. Who? Who's on the in custody? I don't know what to tell her.
Mr. McNally. And Mr.
Oh, okay, let's do that one then. Court does call the case People versus Rashid Abdullah.
Assistant Public Defender Ben Dunawith on behalf of Mr. Abdullah, who is approaching the podium now. Sir, would you please state your name for the record?
Rashid Abdullah.
Your Honor, today's the date and time set for exam. The defense is going to waive.
All right.
And my client has signed the form. I'm providing it to the bailiff now.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count. Sudano.
Your Honor, we will stay in mute and waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 16th at 1:30 with Judge Slay.
July 16, 2026, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Thank you. Court recall. Wait. Oh, I'm busy here.
Oh, my apologies, my apologies.
Okay, it's all right.
Got to go ahead and round it.
Court calls the case People versus Christopher Johnson.
This is on behalf of the people, Your Honor.
Sorry about that, Your Honor. Good morning, Ivan, 65879, appearing on behalf of Mr. Christopher Johnson.
Your name, sir?
Christopher Johnson.
Thank you.
As a preliminary examination at this time.
And we have no objection, Your Honor, to that request for
Are
the,
you moving to dismiss?
we are moving to dismiss without prejudice in this matter, Your Honor.
People being unable to proceed, this case is dismissed as without prejudice on the defendant's motion. Thank you.
Thank you so much, Your Honor. You and your staff, take care.
Thank you.
Were you going to take him down? Yes, you were. Okay. You know, I almost didn't say anything because I wanted to see it happen. I don't know. You need to understand, Alan's a little touchy about that. Court calls the case People versus David Yardley.
Morning, Your Honor. Raymond Cook for the people.
Morning, Honor. Rob J. Cole on behalf of Mr. Yardley, who is a
David Yard. Thank you.
Your Honor, this is a date and time set for preliminary examination. At this time, the people are unable to proceed.
judge. We'd ask this matter be dismissed.
People being unable to proceed, this case is dismissed on defendant's motion without prejudice. All right, thank you.
So it's really have at the moment for you.
Really? That's it? What's Getty here?
Exactly where you at. Oh, ready?
Well, I did not ask that. Oh, that was cute. On Zimmerman. That's a hold. Okay, who's on the other side of that? All right, how many witnesses are we looking?
At minimum 3, depending on their testimony, it could be as many as 6.
Oh, joy. All right. Do I have any other short matters or? Okay, good answer.
So this game is on 2. Don't know. Yes, Scotty is on another pitch. My understanding is those are going to attempt to plead on that. You'll get a paperwork again.
Okay.
Still waiting on 2.
We're waiting on 2 attorneys.
Yeah. Just kidding.
What?
It's part of all small, and I didn't see it. If they're, I don't know what's happening.
I thought I saw Mr. Muller.
Yeah, there are parents here.
Okay. And Ms. Barnwell's out in the hall. That might be a good thing for a while. Saying, oh, wow, Alan, that's rude. What? It's hard being me. And what? Oh, Zenda's leaving? Goodbye, Miss Zenda. Yeah. So Gaines is one here. That's okay, Miss Tanner. You don't have to say goodbye. Goodbye. Oh, okay. No, my bad. Guess I spoke too soon. What's Gaines doing? So how many more do I have left?
2, 3, 4, 5 is outside the whole, so 6.
So 5. Okay. Are any of those going to be short? Because once I start that one, there's not going to be anything in. Good morning.
Your Honor, I know I should have done this before. I believe Ms. Dover and I will have a resolution, and I would request if the court would permit a no contest plea. I do need just a couple minutes to print out the police report, or I could email it.
Okay. If it's probably to email it to, and is that a correct statement, Ms. Dover? It's going to be a no contest. Okay, I'll do that. I'll take a break to go through the report, but if you can get the report to Ann as soon as possible.
Okay.
And then
Your Honor, I also have a quick one with Ms. Barnwell. I think it's not going to go.
okay, does she know that? Yes. Why don't we do that? Today. Check. Please. Third. It is the 23rd.
You are too, Jim. Okay.
Is on another hearing in the hallway. She said,
Oh, so she told me to wait. Okay. Ms. Gaines, good morning. Are we ready on any of yours?
Yep, she just needs a waiver.
A waiver. They're out.
Yes.
This court does call the case People versus Christopher McDade.
And over for the people, Your Honor.
Kelly Gaines, Senior Assistant Public Defender with and on behalf of Mr. McCade, who is approaching the podium.
Your name, sir?
Christopher McDade.
You are waiving your right to a preliminary examination.
Yes, Your Honor.
Understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Correct.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, just to also put on the record our agreement was that Mr. McDade does have a circuit court matter already. And so he is waiving this case with the offer of admitting to count 2 and count 1 being dismissed in a circuit court, keeping all his cases together.
Got it. That's right. All right. As to the arraignment, you waive formal reading. Your client stands muted.
That is correct, Your Honor. We acknowledge and waive reading at this time.
And waive formal reading, standing mute as to both counts. Court will enter not guilty plea. Pretrial will be set
August 25th at 1:30 with Judge Conkey.
August 25th, 2026, 1:30.
Yeah. Thanks, Your Honor.
Bond will continue. Thank you. I think it's only out that form. Ms. Dover's got to sign off on that. For me.
All set, sir.
Okay, thanks, Judge. She wasn't filling out anything. Oh, well, it's okay.
Oh, I already turned in the waiver for it.
Skip.
Yes.
No, she didn't. Okay, I saw it. I know. I saw. Why you got to point it out like that? Like I missed it or something. Why are you doing that to me, man? That's what I'm talking about. Okay, so we have Miss Yagi's that one. Who else? And then Barnwell will be on her way in. That's 3 out of the 5. Right? So I have 2 more left. What was Mr. Mullen's intention?
She believes they're going to come to a resolution. These parties are still working.
Okay. And who's on the other side of that? Okay.
Yeah.
Okay. And then we have one more.
Mr. Hopkins games.
That one I think we're trying to resolve, but no promises.
Okay. All right. I always like the way Cook puts it. Okay, so with all of that going on, then you sent the police report? Oh,
My Wi-Fi was out, so I'm using that phone.
okay. So once that gets to you, I can review that.
If you can, that would be wonderful. Thank you.
Then I can resolve that. We have that one. Barnwell will be ready hopefully soon. And I can take care of that once I can take care of 3, well, including an exam, but okay. That's all I can do. Good morning. I'm sorry. On Barnwell? She's in a hearing, another hearing, probably via Zoom. But Ms. Dover, I think, thought that wasn't going to go. So we may be able to get rid of that. Did he need something from us? No. Well. Guess I'll step on. What did you say? Do I need a break? Think I should take one?
No.
Okay, then I'll sit here. Doing absolutely.
May Mr. Getty and I approach very briefly?
Should have gotten out. Yes.
You,
Oh, I'll put the proctor in, Judge.
okay, thanks. I'm sorry, I need your appearance.
Good morning, Your Honor. Not today, as normal. I have the people, the AA
Statute out here for some reason. It's not too many fish on the line, it's too many lines in the water, right?
I apologize. Too many lines on the water.
I just wanted to make sure.
I apologize. I regret that. I will thank you for the word that you used. It was the deep fishing.
That's okay. No problem. I just wanted to double check with you, sir. To that charge, too many lines in the water, civil infraction, you plead responsible or not responsible?
Responsible.
Okay. I'm gonna fine you $135 total. Lisa, I don't know if that one requires a conservation fee or not. I don't think it does.
It does, but it's already added into the 135.
Perfect. Thank you. You're all set. You can go down the hall and pay that, okay? Thank you. Good luck to you. And I'm dismissing the misdemeanor. Oscar Labrado, Huerta, Nino, 26M, 690-1068. All right, Mr. Vitale, your name?
Yes, thank you, Your Honor. Stephen Vitale, B45601, on behalf of Mr. Huerta Nino, who's here for an arraignment. He'll waive formal reading and he'll stand mute.
Sir, I need you to start your video, Mr. Oscar Huerta Nino. He speaks strictly Spanish. Is that true?
I believe that's correct, Your Honor.
Do you speak Spanish at all?
Do I speak a little bit? He does. He is present with a relative of his too, also on.
Okay, well, can the relative get him online real quick for me, please?
Certainly, Your Honor. I'll text the relative right now.
Look, let's just do this. We're going to get an interpreter, right?
Yes.
Where was he? He didn't show up before, though, twice. So make sure he shows up, okay?
Oh, absolutely.
I'll adjourn this for arraignment and pretrial, Lisa, till what would that be? After July the 12th, they want. So if we could do July the 14th at 9 a.m., and we'll get a Spanish interpreter here, okay, Lisa?
Okay.
So that's what I'll do. I'm just gonna go ahead and adjourn it. Sir, what is your name? Yeah, he doesn't understand me. I'm just gonna go ahead and adjourn the arraignment pre-trial. And we'll get a Spanish interpreter. And you have to convey to him somehow he has to be here on July 14th at 9, okay, Mr. Vitale?
Wonderful. Thank you, Your Honor, very much.
Now, listen, I'd prefer that he be in your well, wait a minute. I don't want to. Where's your office?
My office, Your Honor, is in Troy, Big Beaver and I-75. If you want, Your Honor, I'll bring him to my office and zoom on from there.
Well, that would be either that or you come here. It's easier if you're here with a Spanish interpreter is all I'm saying, but I'll let you do that. Either way, you either have to have them in your office or you two be here, okay?
Thank you, Your Honor.
July 14th at 9, and we'll get the Spanish interpreter. Thank you very much.
Thank you.
People Against Harvey Trucking Services, 26S118459, A and B. How you doing, counsel?
Great, Judge. Paul Young's on behalf of Harvey Trucking.
So we're going to have this is going to be a plea to overweight.
Yes.
And there's agreed upon fines and costs of what? 4150, is that what I read? 4150?
It is.
And then there's going to be a plea to defective equipment with the overheight to be dismissed. And there's agreed upon fines and costs of 150, true?
Yes.
You're authorizing those pleas on behalf of the company?
Yeah, just spoke.
To the charge defective equipment, responsible or not responsible?
Response.
And to the charge of overweight, responsible or not responsible?
Also.
I'll accept those pleas. 150 on the defective equipment, original charge dismissed, overweight accepted. 4150, and I'll give them until July 23rd to pay those, okay?
Okay, sounds great.
Have a good day. Thank you. Thank you.
In person, Zoom. Well, YouTube is what it is.
What's that?
I said, I'll see you in person or on YouTube.
Take care. People Against Commandera, Susan Kathleen Commandera, 26F702945. Mr. Clovis, good morning. Your appearance?
Good morning, Judge Bill Clovis, P38434 on behalf of the defendant. Ma'am, would you please identify yourself for the record?
Susan Kathleen Commandera.
So here's what I can do. I can adjourn the PCC 2 weeks until July the 7th.
Perfect.
And I can give you an exam of the 14th, but I can't adjourn it past that. Okay. So your client can take the waiver. I hope you can get this in there if you can, and I'll go from there. Okay. Fair enough.
Thank you, Judge. It's just, the issues are 30, 35 years ago, prior, a couple of them, and we won't be holding a prelim in any event. So, okay. Thank you.
So Ms. Commandera, your lawyer wants an adjournment. You have the right to a probable cause conference within 14 days of the date of the arraignment. He wants me to adjourn it 2 weeks. I'm willing to do that. But if I do that, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, Your Honor.
Do you waive that right?
Yes, Your Honor.
All right, I'll accept the waiver. We'll set the PCC for July 7th at 9, preliminary exam July 14th at 8:30 or at 10 o'clock. Okay, Lisa, is that good?
Judge, can we do the 7th a little bit later?
Sure. What time do you want me to do
9:30.
9:30. Is that good, Mr. Clovis?
Perfect.
And then July 14th at 10 will be the in-person exam. Is that good, Lisa?
Yes.
Okay, good enough. We'll see you then. Good luck, Mr. Clovis. Thank you.
I
Have a good
don't
day.
see anybody over there. You have a nice 4th of July.
Thank you. You too. Thanks.
Thank you.
Thank you, Your Honor.
So now I'm going to do, I don't know what you have here, counsel. I don't have your file yet, Mr. Hashi. I'm not putting you to the bottom here. So I don't know what happened. Did you talk to the prosecutor yet?
I did, Judge. They're setting for final pretrial, going to subpoena the complaining witness. It's on its way in at some point. No worries.
Ryan Shannon Stamper, 26M700386. Ryan Shannon Stamper, can you unmute and tell me your name, please?
Ryan Shannon.
All right, you're a winner. The officer failed to appear. Case dismissed. Case was scheduled for 9. He was given 15 minutes. It's 9:32. You are all set. Have a great day.
All right. Thank you.
Good luck. Thank you. All right. Did Ayala Williams ever show up, Lisa, if you know?
No, Judge.
I'm going to end up issuing a warrant for her arrest. So when Mr. Batar comes in again, I'll get him out of here. I don't remember, Mr. Hashi. Was that the domestic prosecutor or the regular prosecutor?
Regular, Judge. Mr. Asmar.
Okay, do we have that one? No?
No.
You know, Judge, I'm a little disappointed. I was hoping to see your assistant today as opposed to just having you on the screen.
Yeah.
Especially
Yeah,
on
I know.
Sunday.
She's a lot cuter than I am, isn't she?
That's fine.
Riddell, Aiden Carter Riddell, 26 P12600A and B and C. Do I have a lawyer on this one? Aiden Riddell? Well, come on up. You got to come up here. Okay, all right. Come up to the podium and tell. See, this is the podium right here. That's where you go. Your name?
Aiden right now.
You're charged with not having a valid license on your person and obstructive view, window tint, and not using a seatbelt. 2 civil infractions in this. You have the right to an attorney. If you want one, I'll give you one. Do you want a lawyer? I can't hear you.
That's okay.
All right, I'll go ahead and arraign you and I'll send you to the prosecutor, okay? It was alleged that you did on June 4, 26 at 12:09 p.m. operate a motor vehicle. I can't read this. Wow. This, you're on Metro Parks officer writes almost as bad as I do. It looks like Metro Park Drive in Brownstown. He thinks you're operating a motor vehicle and you did not have a valid license on your person. That is a misdemeanor punishable by up to 100 fines, 90 days jail, plus or all this. You understand that, sir?
Yes, sir.
You got to keep your voice up for me, okay? And then you have a second charge of seatbelt violation. That's a 0-pointer. And then you have obstructive view, window tint. You have those two. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You got to keep your voice up.
Yes, sir.
You still wish to waive your right to a lawyer?
You're a public defender.
I'll give you a public defender if you want one. You're entitled to one by law. $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I will give you a defense lawyer. Okay?
Sir.
And you are all set. Thank you very much. Go out there and we will set you up with a defense attorney. Did you guys resolve that one, counsel, or not?
Judge, we're going to keep the dates, but we're going to resolve it.
So I'm going to set a final pretrial?
That makes sense.
Okay, I'll do that. Do you have, is that Vukovic? Okay, people against Vukovic. Vukovic, Stevie Vukovic, 260-710-812. All right, good morning. Your name?
We are running shy on behalf of Mr.
All right.
Stevie Vukovic.
All right, so we're going to keep the jury trial on for July 24 at 8:30. Lisa, I want to set a final pretrial and I want to make sure I'm here though, but I'm not going to be on the 7th. If I set it for the 14th, that means you guys will have to send out the notices, right? Before then?
Yeah, that's okay. I can do that.
We're going to put a final pretrial on for the 14th. What time's good for you, counsel?
Judge, morning works.
You tell me the time.
8:30, I'll be here, right?
8. Maybe they will be next time too. 8:30 in the morning, July 14th at 8:30, July 24th at 8:30. With the jury instructions, I'm going to ask you to get with Ms. Holloway and you guys can submit them. I want to have them typed up where she doesn't have to do all of these. It has everything. All I got to do is read them. Okay. And if there's objections, I'll be more than happy to handle those. Okay.
Have a good day.
Have a good day. Thanks a lot.
Thank you.
I'm sorry I had to make you wait.
Not at all.
This is Robert Joseph MacArthur and 26G7091562. And I also have Robert Nicholas MacArthur, 26G7091561. All right, everybody's name,
Judge, good morning. Vincent Hayes on behalf of both MacArthurs.
your name, sir,
Robert McCarter, Robert Nichols.
and your name.
Good morning, Robert Joseph McCarter.
Did you guys both go over and get printed? You did, right?
We did, sir.
Okay, so we're gonna set a final pretrial. Let me see here. So let's,
Could we do the 14th, Judge? I know you were looking at the 7th and the 14th for some other dates. I'm in
I
Howell.
can't do this. I'm not gonna be here the 7th. Judge Huston's gonna handle my probable cause conferences, but I'll set it for the 14th.
Excellent.
Set another pretrial for the 14th of July, and I can set that as early as you want. What time do you want?
I have an 8:45, so if we could do 9:30, that'd be perfect.
Okay. July the 14th at 9:30. July the 14th at 9:30.
Excellent, Judge.
You have your clients in your office. I'd prefer that either you both be here or none of you are here.
They reside in Florida, Judge. You had previously said that they could Zoom in. They came in specifically for today because they had to get the fingerprints done.
I see. No problem. Okay, you guys can Zoom in July 14th at 9:30, okay? Lisa, I want to make sure I'm looking at warrant issued on May 13th. I just want to make sure that that was canceled.
Yes, it was canceled
Okay, okay, good enough.
on both of them.
You guys are all set. Go down the hall, get your new notices. You can Zoom, okay?
Okay, thank you, Your Honor.
On July 14th. Have a good day. Thanks, Mr. Haysha.
Hey, thanks, Judge. Good to see you. Take care.
You too. Thank you. Do I have Valley Trucking? Let me see here. Valley Transport Inc., 268-118-466. Good morning, Mr. Calvert. How are you?
I'm doing well. How about yourself, Your Honor? Good morning.
Good. Your appearance?
Danny Calvert appearing on behalf of Valley Transport Inc. They are not present, but I have authority to act on their behalf.
All right. You're going to plead to overweight, and there's agreed upon fines and costs of $1,800. True?
That is correct, Your Honor.
You're
Yes.
authorized to enter this plea on behalf of the defendant?
Yes.
To that charge of overweight, responsible or not responsible?
Responsible.
Plea is accepted. Fines cost $1,800, paid by July the 23rd.
Appreciate
Okay?
it. Thank you very much.
Have a good day.
You too. Thanks.
Did you already meet with the prosecutor, Mr. McDermott?
Yes, Judge, we're ready.
Okay. Let's see, maybe this is yours. You have G Logistics? Yeah.
Yes, Judge.
Okay. G Logistics LLC, 266-118-148. Good morning. Your appearance?
Sean McDermott, P46101 on behalf of G Logistics. Judge, we do have a resolution whereby the original fine will be reduced to $5,200 with 30 days to pay. I do have full authority on behalf of the company.
And you plead responsible on their behalf?
I do, Judge.
Please accepted, $5,200, paid by July 23rd. You're all set. Have a great day.
Take
Thanks.
care, Judge.
Are you out in Fenton?
Yes, Judge.
Have you been out in Fenton that whole time?
Yeah, since 2000.
Wow, that's quite a ways. Well, I guess Zoom helps you out. Take
Absolutely.
care.
All right,
Have a
take care,
good
Judge.
day. See ya. My good buddy Bocus lives out there, you know.
Oh,
He's
does he?
Well,
Whereabouts?
he's actually in Linden. You know,
Oh.
Judge Bocus?
Oh, Judge Bocus. Okay, sure. Yep.
Yeah, and he's out there. So, yeah, I don't know if you remember him, but he was just a great man. I
Yeah,
love
yeah.
that guy.
Absolutely.
Have a good day.
All right,
See ya.
take care.
All right, did Mr. Patar come back yet? Well, you see, he didn't, did he?
No, not yet. John, we can put Workman up. He's on Zoom.
Workman?
Is he in there?
No.
John.
Good morning. This is
He did-
Detective Atard from Brownstown PD. How are you doing?
Good, Detective. How are you?
Good.
Hi.
So
Yeah, I can come down there right now if you want. Okay. Bye.
Which one was it, Lisa? I can see if I can grab.
Workman, she said, I think. So they're going to find that. I'm going to go down and talk to Lisa for a moment. We'll go off the record. Albert Workman, 260-241468. David Workman here. David Albert Workman. He's on Zoom, right, Lisa?
Sorry, Judge, I just got back down here. Who'd you call?
That's okay. Workman. Do you know where Workman is?
Yes,
David
he's
Work-
on Zoom.
Okay. People against David Albert Workman. 260-241468. Good morning, sir. Your name?
David Workman.
All right. You're charged with having open intoxicants in a motor vehicle. They give you warnings on a couple other charges. You have the
Yes,
right
sir.
to an attorney. If you want one, I will give you one. Would you like
No,
an
thanks.
attorney? Pardon?
No, thanks.
All right, so I'll go ahead and arraign you and I'll send you to the prosecutor. It is alleged that you did on June the 5th of 26 have open intoxicants in your motor vehicle on Jefferson near Petros in Rockwood at 6:19 p.m. That is a misdemeanor. It is punishable by up to 100 fines, 90 days jail, costs are all those 2 points. Do you understand that, sir?
Yes, sir.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to testify at a trial, cross-examine witnesses at a trial, use the subpoena powers of the court to bring in your witnesses at a trial. And you have the right to remain silent. If you plead guilty, you're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. And there will be no trial of any kind. Do you understand that?
Yes, sir.
Still wish to waive your right to a lawyer.
Yes, I don't want a lawyer.
I'll enter an not guilty plea. I'll give you $100 personal bond. You do not have to post any money. You can leave the state. You live in Kentucky, right, sir?
Yes, sir.
You can leave the state without consent. I'm going to set you up with the prosecutor by Zoom, and she'll, negotiate with her, see what she'll do for you. Okay.
Okay.
So we'll take this to the prosecutor, and she'll meet with you very shortly.
Yes.
This one has to go to the prosecutor.
Okay.
Are you a lawyer? I thought so. What's your name?
My name, Alyssa Segura.
Are you on a case? What case do you have?
My last name is Golden. but
Okay.
It doesn't appear the jail signed in yet.
Okay. Okay.
Go the wrong way.
Okay. Good enough. No problem.
She'll be seeing.
Judge, who is she here on?
I will be.
Will be.
Well, just don't be yelling at me at any point.
As long as you shouldn't be.
She's on Golden. That's Ms. Segura. She's on Golden.
Okay. Golden is on Zoom.
I'm going.
Perfect. Thanks. All right. Oh, she's from NDS. What's that?
Want to try to talk to Alloway?
Oh, yeah. Ms. Holloway. Can you come in here when you get a minute, Ms. Holloway?
Or do you need to speak to your client? You're muted.
Oh,
Do you need to speak to your client?
no, I do not.
Okay, be just a minute.
Hey, Ms. Holloway, I'd like you to come in and talk to me about a couple of these cases here. I want to set up a conference call with you and the lawyers if you'll. Thanks.
Judge, Mr. Batar is back also.
Who is?
Mr. Batar for
Batar?
Williams.
Okay, bring him in. People against Ayalia Vandian Williams, 25E716796. Good morning again, Mr. Batar. Your appearance?
Good morning, Judge Daniel Batar on behalf of Ms. Williams.
I don't know what to tell you. She never showed up.
I did some research, Judge. I can't find her anywhere else. She has a case pending in Calhoun County, but I contacted that jail. She's not locked up on it.
I'm going to just issue a warrant. What's that?
She posted and I've been looking all over too. I can't find her.
I know. I don't think she ever showed up. Defendant failed to appear. Bench warrant to issue. forfeit bond. I mean, obviously, if she comes in, I'll reschedule as long as she's in the next 24 hours. Otherwise, I'm gonna go 20,000, 10% on her, okay?
Thank you, Judge. And what was the bond she already posted, the amount?
Posted 4,000, 10%. There's a third party poster.
Okay.
Have a good
All right.
day. Thank
Thank
you.
you. Take care.
All right, Ms. Ford, how are you doing? Which one do
Good
you
morning,
have?
Your Honor.
Which
I
one do you
have-
have today?
Mr. Well, I'm frozen.
Dairy man.
Thank you. He's present. I've texted with him many times this morning.
Ms. Holloway, you got 2 jury trials in front of me on Friday.
Yes, Your Honor.
I would like you to do something right now for me. Can you call the other 2 lawyers and say, I'd like to set up a phone conference this afternoon or a Zoom conference, if possible, with both you and each of these lawyers?
There is one of them that I don't believe will be going. That one will likely not go.
Which one's that?
Staffage.
Okay. Is there going to be a resolution or what's going to happen?
Victim is no longer cooperating.
Well, then let's set up Zoom calls on both of those with the defense lawyers. Will you do that for me, please? We can do it by Zoom. I would prefer early afternoon. Like 1 or 1:30, if you'll be available to do it then.
Right now.
Ms. Golden, your lawyer that was Ms.
Yeah, she needs to join the breakout room.
You need to join the breakout room, Ms. Golden, okay? Join the breakout room.
It's right on your screen.
Good morning. Hey, how you doing? I'm like, I'm good. How about you? Good. Good. So early afternoon, 1 or 1:30?
Whatever's good for you guys. I have sobriety court at 3.
Ben, how are you doing?
It's been okay.
Wayne County Jail, can you join the breakout room?
Wayne County Jail, I don't know if you heard that. Can you please join the breakout room? I'm talking to, I think, Evelyn Cook, right?
Yes, Evelyn Cook, the attorney's in there.
Okay. Ms. Cook, can you get a deputy if you can hear me and have them unmute you and how you doing? How are you?
Good, how are you?
Good. You're looking awful happy.
I came back from California yesterday.
California?
I am happy.
Good. Ms. Cook, we're going to have you join the breakout room and we're going to have you speak with your lawyer. That's good. Whereabouts in California?
Oh, I was in San Diego.
Oh, that's a tough place to take.
How was your weekend?
Fantastic. That's nice. You're going to they must be paying the prosecutor's office too much money to be going to San Diego for a weekend.
I will let you know later on.
Thank you very much. Okay. Dari Mann. Dari Alonzo Emmanuel Mann, 26B 712-364. Ms. Mann, can you unmute, start your video and state your name?
Mr. Mann, state your name.
That's Dairy Man.
You got to start your video. There you go. How you doing, Mr. Mann? My apologies.
How you doing? How you doing,
good.
sir?
Good. And Ms. Ford, your appearance?
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Dairy Man.
So we're continuing to the exam July 14th at
Yes,
10:30, right?
10:45.
I thought I said it for 10:30. Did I, Lisa, or not? I don't care if it's 10:45. We
Oh,
can do
I'm
10.
just going by what she said today.
I have 10:45 in the system. Do you want me to
Okay.
change it to 10:30?
Nope, 10:45 is fine. That's what we'll make it. Continue to the exam. So, sir, you have to be here in person on that day, okay?
Yes, sir.
All right. Anything else, Ms. Ford?
No, Your Honor, thank you. I'll be there as well.
Have a good day. Thank you very much.
Okay.
Mr. Workman, let's see. Yeah, I don't know if I can do that. Call in Mrs. Morrow in here, will you?
Judge, all right, yeah, fine.
All right. People against David Albert Workman, 260-241468. Okay, Mr. Workman, your name?
David Workman.
Let me check on something, okay?
Yes.
Probation. You want to go on probation for this, Mr. Workman? What's your record like?
I've never had a ticket in my life until this one.
Your name?
Nothing I remember people.
I don't think I can do this. I can't take an open intox. That's on your traffic record. I can't do that under 771.1. You want to just, unless you have evidence that he's had any priors, maybe you can just give him civil infraction. You're not going to do this stupid thing again, are you, Mr. Workman?
No, sir. Lesson learned.
What do you want to give him?
You want somewhere.
You can give him one of those warnings if you want. Give him expired plate or something. Was this a commercial vehicle?
No, sir. It's a personal boat.
Why don't you just give him expired plate? Are you okay with that?
Yes, but the reason it was a warning, the state of Kentucky doesn't require a trailer plate, so I don't know what that would do. I don't understand how it would work.
Well,
I had vegetation hanging off my boat trailer. They cited me
Hold
for
on a
that
second.
too.
Hold on a second. Would you say?
I just wanted to confirm, is the expired plate as a civil infraction?
Yes, expired plate is a civil infraction. You want to plead to a civil infraction, not an open intox. That won't look good on your record. I promise you. Expired plate's a lot better for you than that. And she wanted me to put you on probation. I'm not going to do that because you're going to learn your lesson and not do something silly like this again, right?
Yes, sir.
All right. She's going to write it up expired plate. You good with that? Civil infraction, dismiss the open intox?
Yes, sir.
All right. To the charge expired plate, responsible or not responsible?
Responsible.
Plea is accepted. $140. You can pay that online today, sir. 33court.com.
Yes, sir.
Go ahead and pay that $140 and you're all set. Okay.
Okay.
Good luck to you. Have a good day.
You too. Thanks.
Good morning, judges.
How you doing, Mr. Graziani?
Good. Even though my golf game is back up.
None of ours are. I'm telling you. Should have stuck with tennis is what I should have done.
That's an old rough story, but I'm getting forward.
Yeah, I don't think I'd want to be running around out there at my age either.
Thank you.
All right, so what do we have here, Ms. Cook?
Being dismissed.
You got one dismissed. What a great country. Evelyn Valerie Cook, 22T705-215.
Good afternoon, Judge.
And good morning, Judge. John Dropsy, on behalf of Evelyn Cook.
Ma'am, your name?
Evelyn Cook.
All right, let me read this. It says people cannot move forward. The victim's advocate spoke to complaining witness on 6-something. He didn't want to come and participate in prosecution. Is that what you're saying?
That is correct. In addition to that, Judge, this is a matter that dates from, I believe, 2022, and there's some issues that involve that would be involved anyway with the prosecution, but nonetheless, we're happy with the outcome.
Well, I can understand that. Motion of the prosecutor, ma'am. I'm going to go ahead and dismiss your case. Do you have any other holds?
She's got a hold, I believe, Judge, in Wyandotte, the 27th District Court, Wyandotte Riverview City.
All right, so we're going to cancel the bond conditions on this, Lisa, okay? I wish you well. I hope you get your life in order, young lady.
That's exactly what I'm trying to do.
Well, you know, it can't be any fun. How old are you?
How old are you?
How old are you?
58. I couldn't hear because there's people outside here talking.
58. You shouldn't be hanging out in the jail. Come on, stop doing this. Case dismissed. Cancel the bond conditions. Good luck, ma'am. Thank you.
Thank you.
Ma'am, what are you here on the back there?
Judge spoke.
Oh, I'm sorry. I believe my son is coming in this morning and we waited here.
What's your son's name?
Poindexter.
It's the defendants that are coming over from Woodhaven, Judge.
Oh, I see. Whatever. Okay.
They told me to wait here. Would you like me to step outside or wait?
No. You can stay wherever you want. I just was trying, you're fine there. If you want to sit there, you're fine. You want to go out in the hall?
See how this all works. Thank you, sir.
I just wanted to make sure you were taken care of.
Yes, sir.
Judge, I'm going to bring some additional stuff down for that Cowger file.
Sure. You want me to come down there? It looks like I'm not busy. You want me to come down there, Lisa?
It's up to you. I don't mind walking.
Walk down there. I need a
Okay.
nice. Complainant not.
I'm trying to see a white. For the PR trial, she said she can get on now. I can speak to her and we can come to you and let you know if there's a resolution on the trial.
Let me talk to you, see if she can wait about 15 minutes. I'll get these out of here and I'll go on Zoom or what have you. All right. Brianna Lawan Jean Golden, 260-713-794. Ms. Golden, good morning. Your name?
Good morning, Rihanna Lawan Janae Golden.
Good morning, Ms. Segura.
Good morning. This is the girl with the name of the Defender Service, P86-432, appearing on behalf of Ms. Golden.
All right, so we're just going to proceed to the exam next week at 10:45, correct?
That is correct, Judge.
All right, we'll proceed to exam June 30th at 10:45. You do have to be here in person. You understand that, correct, Ms. Golden?
Yes, sir.
All right, Detective Petard, you're on this one?
Yes, Your Honor. Good morning.
All right, so we'll see you next week, the 30th at 10:45, okay?
Sounds good. Thank you.
Thank you very much. Have a good day.
Thank you.
You too.
You're all set, Ms. Golden. I'll call you later.
Jordan Chelsea, Judge, 26R712668.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Jordan Judge, who stands to my right. Say your name for the record. Jordan Judge.
All right, so call in Ms. Holloway, okay? She's saying here that the people cannot, complainant not present for exam, people cannot proceed. It was scheduled for 10. And she's here.
That is correct, Your Honor. I did speak with Ms. Alley, and she indicated that the complaining witness obviously is not here. We did look in the lobby and in the courtroom, but they are not present.
All right, did you get a hold of Ms. Holloway?
Yeah, she said she's on her way now.
All right, how are you? Your name? Complaining witness, you wrote down complainant not present, complainant not present for exam, people cannot proceed.
Yes.
Has the victim's advocate had any contact with the complainant?
Your Honor, yes, and she advised that she will not be showing up today.
Okay.
At this time, Your Honor, you're going for dismissal.
Case dismissed, motion of defense, prosecution unable to proceed. Lisa, make sure you take out those bond conditions, okay? All right, we're all set. Good luck. Thank you. Oh, wait a minute. Was there a bond in this? I don't remember. No, it was a FIAR bond, so you're all set. Thank you very much. Griffer, Ryan Joseph Griffer, 26B711925.
Good morning, Judge and staff. John Roxanne, here on behalf of Ryan Griffer.
Good morning, Ryan. On behalf of the people.
Mr. Griffer will be to my left. Please identify yourself, sir. Ryan Joseph Griffer.
Okay, what are we doing on this? Setting it for
A bench trial, Judge. I have no problem with one. I feel we have no problem with bench trial.
And Your Honor, there could be a potential resolution in the meantime as well. We set it out.
I'll do that. So we're gonna set it for a bench in a final pretrial, right? People have any objection to waiver of a jury?
I have no objection.
Mr. Griffer, do you understand what your lawyers just said?
Yes, sir.
So you understand you have the constitutional right to a jury trial. That jury trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that? If you wish to waive your right to a jury trial, anybody force you to do that? All right, I'll accept the waiver. We'll set it for a bench and a final pretrial. So why don't we go, what do you guys want to do? Can we go to, how long do you want for an adjournment for the final pretrial, I should say?
Judge, realistically, I feel that this matter can be resolved as Mrs. Holloway had indicated.
You want to just set it for next?
Quite frankly, like a final pretrial because we finally begun presenting.
No, I understand.
Issues. Mr. Dino Guzzi is assisting me at this time. He's an investigator and we had information that could benefit our case.
Your Honor, I think a few weeks for trial, we can say July 15th. I think that's what you could say.
For a trial?
Yeah.
And I could set the final pretrial for June 30th. Is that fair?
That's fair, Judge.
June 30 at what time, Lisa, will be the final pretrial?
9:45.
And then the bench trial will be July 14th at what time?
Do you want to do the afternoon?
I'll do whatever you want. I mean, I can do it at 1 o'clock in the afternoon if that's not interfering with Judge Hudson in any way.
No, she doesn't have anything that day.
Okay, so we'll set it at 1 o'clock on July the 14th.
Thank you, Judge.
Will I have sobriety court? No, I won't. So that'll work out. Okay, perfect.
Thank you.
Thank you very much. Good luck, sir. You're going to go down the hall and get your notice. Thank you. Matthew Blake Leone. This is file number 26G710217. Is this Ms. Osmaros or Miss?
That is, Mrs. Holloway's judge. Nora Holloway.
I can't.
What happened?
Ms. Holloway, are you here? I can't dismiss when it's different if it's set for trial. Call me in here again, please. I mean, she's going to have to move to dismiss this one.
Understood, Judge.
237, Jan.
Yeah, I don't know. She's probably not in there.
All right, so when she zooms back in, I'll call it again.
Okay, thank you, Judge.
No, you stay right there.
Okay.
I don't think it's going to take her long.
She's in a breakout room with an attorney. Oh, she just came out.
People against Matthew B. Leone. 26G710217. Your name?
Nora Holloway on behalf of the people.
John Graziani on behalf of Bentley Loan.
Sir, your name?
Matthew Blake Leone.
It's nice that listen, I don't feel like if it's set for trial, that's different. This is only set for a pre-trial. So if you're saying that the complainant can't proceed or complainant's not present, not cooperative, have never appeared, you're going to have to move to dismiss this one.
Yes, Your Honor. I don't believe this. I think this might be the second or third time we have appeared for this case.
The problem, I don't have a problem with you, but I don't feel like it's my province to dismiss the case if it's not set for exam or trial.
The people would move to Nally Pros, Your Honor.
Please dismiss from the prosecutor, and I'm going to go ahead, Mr. Graziani. We're going to make sure, Lisa, that the bond conditions are canceled as well, okay? Thank you. Thank you. I'm making this note of that. You are all set, sir. Have a good day. Good luck.
Appreciate it.
Now, wait a minute. You got a tether on too, don't you?
No, sir.
Oh, no, I didn't order a tether. I just ordered you not to be within 2 miles. We'll cancel those bond conditions. Best of luck. Thanks. Thanks, Ms. Holloway. And is she ready now? Does she want to get on the line now, Ms. White?
She's in the breakout room.
How can I do this?
Breakout?
Lisa, how can I do this? I'm going to
If you'd like, Your Honor, I can speak to her first and we can come back to you.
Let's just put her in. Folks, I'm going to ask you to just leave the courtroom right now for a second here, okay? It won't be long. I'm not conducting a court proceeding. It's more of a settlement conference. Do you have that file, Ms. Holloway?
Oh, I put it in me.
Where?
You want me to go off record?
Yeah, go off record, and I'm going to need the file.
Judge, you're on YouTube also.
Oh, take me off YouTube too.
Your Honor, I do not have the file. It was not up for today.
No, I know.
Are wanting to contest these charges. You understand that? Yes, Your Honor. Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Yes, Your Honor. All right. Basis for the no contest plea, Mr.
Lack of memory, Your Honor.
All right. Sir, to the charge of use of a controlled substance, that being cocaine, how do you plead? No contest. To that same charge in count 4, use of a controlled substance, that being methamphetamine, how do you plead? No contest. Now, you understand a controlled substance, that being methamphetamine, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, Your Honor.
All right. Look at paragraph 5. You'll see a copy on the post. Rights are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand giving up the right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you? It's been stated here today.
No, sir.
Anybody threaten you or
No.
you're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Washington County Sheriff's Office report for their case number 26-34924. Any objection to the court having reviewed that report?
No, Your Honor, thank you.
Based upon a review of that report, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to apprise you that if between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 23rd at 10 a.m.
July 23rd, 2026, 10 a.m. before Judge Washington.
Your Honor, may I bring something to the court's attention? He is being sentenced by Judge Washington on July 7th for a different misdemeanor. I don't know if there's any chance or if we could maybe follow up with the 14B court, but I don't know if there's any chance he could be sentenced for both on the same day.
There's a chance, but
Okay.
it's going to be up to 14B. I'm going to give the date they gave us.
Okay.
And then you can talk to them and see whether or not they'd be in a position to sentence him on that date.
Understood. Thank you, Your Honor.
All right. Bond will continue.
And I'm sorry to make this difficult. Does Your Honor have, Mr. Kelly wanted me to address bond. I don't believe he's being held on this case. And I believe he's being held on the other misdemeanor for which he's pending sentence before Judge Washington. I know there's an issue with the GPS tether, and I looked at our arraignments notes, which indicate that there was no tether ordered for this case.
Not being held on this case.
Thank you, Your Honor.
You got a personal one.
Thank you, Your Honor.
Thank you.
All right, we'll follow up with you by brother case. Okay, thank you, Your Honor.
Court calls the case People versus Brianna Force.
Morning, Your Honor. Wendy Barnwell, P42505, on behalf of Miss Brianna Force, who is still in Detroit at the transit center, waiting for a delayed bus to get to Ann Arbor. She texted me the itinerary of this delayed bus.
Okay, so what would you like me to do?
I don't know if perhaps I can talk to her and tell her. I don't know that this court would allow her to Zoom, but can we approach? Please, Judge.
Sure.
Sorry.
Looks like we had a brief bench conference in that case, and I'll pass that matter momentarily. And Miss Force, she'll be signing it.
Oh, okay.
But I don't know if she
I'll make
wants
sure.
to put her name, but somebody will sign it.
Okay, yes. That'll.
Court calls case, People versus Tepe Story.
Joining Senior Assistant Public Defender, Representative Schwartz.
Your name, ma'am?
That's Tepe Story.
All right, she's waiving.
That is correct, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right, I'm sorry.
Yes, Your Honor, there was an offer that was extended by my place out on the record.
Yes.
The offer was she could either take the plea today or waive up and take the plea at the first circuit court pretrial. The offer being to plead to an added count 4 of attempted resisting obstructing, as well as an added count 5 of assault or assault and battery, that being the 1 year and the 93-day misdemeanors respectively, with counts 1 through 3 being dismissed upon acceptance of plea.
That is correct, Your Honor.
That's correct.
Okay.
All right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. Ms. Gaines.
Your Honor, we acknowledge receipt of the information and waive its reading. At this time, my client wishes to stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 17th at 1:30 with Judge McNally.
August 17, 2026, 1:30, Judge Hamoud. Thank you.
Thankful.
He needs to sign off on. All right. Are we,
I don't know what.
so right, but at least there was a witness that had an appointment, and so I'm going to start and get that witness out of the way so they can get on their way. And then maybe we can figure out the other one.
I'll call for
So I only have 2.
Other than that, yes,
Other than that,
correct. You have Miss Force and then you have Mr. Mullins.
got it. Okay. I force it on Mr. Mullins' case. All
Okay,
right.
I will call for the defendants.
All right. Very good. We're ready on Zimmerman, is that correct?
You are ready, Your Honor. Ready.
Court does call the case of the People versus Kyle Zimmerman.
Your Honor, bring the book to you.
And thank you, Your Honor. Alex Warren Green on behalf of Mr. Zimmerman. Mr. Zimmerman, could you please state your name for the court?
Hi, Mr. Zimmerman. Michael Geddes. Mr. Zimmerman.
All right, very good. All right.
The preliminary examination, the people are ready to proceed. There are a couple preliminary housekeeping matters. We can address those for you.
Yes.
Just first and foremost, I'm not sure if the defense is handling one witness. I know I have a number of witnesses. I think that's registration before.
At this point, the defense does not plan to call any witnesses. We would likewise ask for sequestration.
All right, all witnesses are hereby ordered to question from the courtroom and should not discuss their testimony or impending testimony with any other witness.
Thank you, Your Honor. As a second matter, I informed Mr. Getty, I think it was brought up on the record at the last PCC, people are intending, if the evidence shows, to add 2 additional counts to the information, that being account 5 of bank robbery, as well as account 6 of felony firearm in relation to that bank robbery. Finally, Your Honor, I believe there is a stipulation as to prior felony conviction, that being the attempt robbery, the Third Circuit Court.
And so for the
felon in possession, I believe it's going to be
felony in possession, the predicate felony, you're stipulating this one does exist.
We would stipulate, Your Honor.
All right.
For exam purposes.
Understood.
I believe that's all the housekeeping matters I have before we begin testimony.
Anything additional for the defense?
Your Honor, I would just state with respect to the potential of added counts, I related that to my point, the potential consequences that come along with that, but I have nothing further at this time.
All right. And I do, so that I know this isn't a surprise today because I recall it being mentioned at the last BCC.
And also just
As to the bank robbery, yes, Judge. As to the bank robbery, yes.
But not as to the felony firearm you're indicating?
That is correct, Your Honor, but Mr. Cook told me this morning.
Okay.
And just to make clear, those counts are going to be added regardless if the defendant waived or held the exam.
Whether he waived or held.
Correct.
Okay. All right. Very good. All right. There being nothing else, call your first witness.
Melon Law.
And please come forward and be sworn.
We take a seat, raise your right hand. You solemnly swear in front of the testimony, truth, the whole truth, and nothing but the truth, so help you God. State and spell your first and last name for the record, please.
My name is Melanie Hall. MELD HOFF.
Very good. Main choir.
Thank you. Good morning, Ms. Hoff. How are you? Ma'am, I want to draw your attention back to December 5th of 2025. Do you remember that day?
Of course.
And specifically in the late morning, early afternoon, were you ever at a Chase Bank?
Yes.
Which Chase Bank were you at?
At Westgate.
Is that 24 West Stadium Boulevard? Is that here in Washtenaw County? What were you doing at the bank?
I went inside so I asked the teller about the money bills, the different kind of bills I wanted to get for withdrawing cash.
Did anything out of the ordinary happen while you were having that conversation?
The teller and I were discussing the bills, and the next thing I heard was, this is a holdup, give me your cash.
Were you able to see who said that?
Well, I turned and looked at the person. The person had on a mask and a hat. And what I really saw was the gun that was pointed directly at me.
What sort of gun was pointed at you?
Well, I'm not an expert, but you know, a pistol.
Okay. Who was holding that gun?
The person who was holding up the bag.
That was the person that you made that exclamation prior?
Yeah.
Okay. Had you ever met that individual before?
No.
Can you describe what that individual was wearing?
Well, he had on a, one of those hats that folds over, a big cap and the mask. And then he had, because it was December, a heavy coat.
What did this individual do with the gun?
He pointed it at me.
Did he make any statement other than the previous statement that you said?
Not that I can recall.
How long was the gun pointed at you?
Well, I sort of responded in fright, and I immediately removed myself and crouched behind a sign. So it was, I don't know, 1-2 minutes. I don't know, because I went around to the sign and hung up.
When you say it was 1-2 minutes, are you referring to the whole interaction or the amount of time the defendant, or I'm sorry, that this individual had the gun pointed at you?
Oh, sorry, I can't.
Okay, that's fine.
Why?
What happened after this individual made that exclamation?
Well, I don't remember what I did, but witnesses told me I screamed.
So, that would be hearsay, so
Okay, but
you go ahead.
I lost my voice.
Do you remember how you felt when this was happening?
Scared.
Did you ever think at any point that that gun would be used against you?
Of course I did.
Do you know if that gun was loaded or not?
No idea.
I'm going to go a little bit out of order here, Your Honor.
I'm trying.
Showing defense counsel what's been marked as People's Proposed Exhibit 2. May I approach the witness?
You may.
Ma'am, what's been marked as People's Proposed Exhibit 2. Please take a look at that document and tell me what it is.
That's the person who confronted me.
Is this photograph a fair and accurate reflection or photograph of the attire and the outfit that that individual was wearing that day? Your Honor, move to admit what's marked as People's Proposed Exhibit number 2.
Any objection or what here?
No objection.
Exhibit 2 is admitted.
I am a copy for the court. Permission to publish?
Yes.
How long was that individual in the bank that morning?
Sorry, I can't really tell you that answer.
Okay. Were you injured in any?
No.
Did this individual ever discharge the weapon?
What do you mean by this?
Did they ever shoot it or did they ever?
No.
Oh. If I can have just 1 second, please, Your Honor.
Well, you do that. I just want to clarify one thing. In the bank, I've never been in that bank. So are there a series of windows and you were at one of them?
Correct. And I there was nobody else at the other windows.
Okay.
And there were no other customers waiting in line. It was pretty empty.
Okay. Okay. And so you're at one of the windows talking to the teller, and that's when what you described occurred.
Yes.
Okay. Thank you. Go ahead, Mr. Cook.
Nothing further for this witness. I would pass.
All right. Nothing further. Cross-examination.
Good morning, Ms. Hoff. My name's Alex Warren, represent Mr. Zimmerman in this case. Ms. Hoff, you described the person you saw at the bank that morning as a white male with a zip-up hoodie and a beanie. Is that correct?
Yes. Yeah. Okay. Thank you, ma'am.
Okay. And you said that person produced a gun. You said they pointed it at you. Okay. And I'm not sure if you described it in your direct examination with the prosecutor, but you said the gun looked silver. Is that your recollection? Okay. And on your direct testimony, you said that the person said something to the effect of, "This is a holdup, give me the cash." Is that correct? Okay. You remember at the time of the incident being asked to provide a statement to the bank, do you?
You mean afterwards?
Yes.
It's kind of a blur to me. After the incident and the person left, they just had me sit in a chair all by myself. And then somebody came probably 20 minutes to a half hour later, who's a representative of the bank, and they asked me questions, but I don't know if it was a statement per se.
Okay. You remember telling someone at the bank that you did not wish to give a statement because you weren't sure if you were in the right mindset, maybe?
Oh, no, I said that.
Okay. You remember telling someone from the bank, and I don't want to mischaracterize what you did or didn't tell them, so correct me if I'm wrong. You remember telling them you weren't sure you could fill it out accurately at the time due to the stress of the incident?
I don't have any recollection of that. What I do have recollection of was that everything seemed to be taking a long time. And I just wanted to leave the bank and get home. And so they wanted me to talk to some, I don't know if it was a psychologist or whatever, but I said, I'm fine. I just want to go home. I have Pilates class at 1 and I wanted to. So I did. I remember denying psychological help, but I don't remember anything else.
Okay. You did talk to a police officer, right?
Yeah, I'm pretty sure I did. I know I talked to people afterwards. They called me on the phone. Because what happened that day, I can't remember all the specific details. I remember it took a long time for the police.
Okay. You remember telling the police officer that you were uncertain exactly what the white male with the zip up hoodie said?
I don't recall.
If I showed you a written report from the officer you spoke to, do you think that might help refresh your recollection?
If you want to show it to me, that's fine.
Okay. Do you think that would help refresh your recall of what you told the officer?
Possibly.
Okay. Your Honor, may I approach with that?
Okay.
Thank you. Ms. Hoff, can you tell me if reviewing that refreshes your recollection when you've had an opportunity to do that?
I see that, but
May I approach you on?
Right.
Ms. Hoff, did that refresh your recall of what?
particularly.
Okay. In this case, you were never asked to identify a suspect by being shown an array of pictures, were you?
Never asked because they had all the footage from the bank.
Sure. You were never brought to a police station and shown a lineup of people? Okay. Your Honor, I have nothing further at this time. Ms. Hoff, I appreciate your time.
Hold on one moment, Ms. Hoff. We'll get you out of here. Is there any redirect?
No, Your Honor.
All right. Ms. Hoff, thank you very much. You may step down.
Were we continuing with this exam? I thought I heard the court said it has some other matters that it wants.
Well,
think I cleared everything but one, but I didn't have a status on Mr. Mullen and Mr. Kennedy.
I don't know where they are.
I've seen them go in and out, so you're gonna go check. I just want to know if they're ready. If it's something simple, then fine, but.
However.
If they're not ready, we can try to get one or two. I have to take a break to do one thing.
Understood. We'll call Raven Roberts. I will go grab her.
All right. Yes.
Yes.
You signed in.
Well, I was just hanging out. That's on his side.
Okay.
So you just like.
Gotcha. Let's try to get this one in there. All right, ma'am, come forward to be sworn.
We can take a seat, raise your right hand. Do you solemnly swear upon the testimony about to give the whole truth and nothing but the truth, so help you God?
Yes.
Absolutely. Can you spell your first and last name?
Name is Raven Roberts. My name is.
Okay, you may inquire. Thank you. Good morning, Ms. Roberts. How are you doing? Ma'am, I want to draw your attention back to December 5th, 2025. Do you remember that day? How are you employed on that day? Do you remember which branch of the Chase Bank you work for? Do you remember the address for that bank? Were you working that day? When were you working? At any points during that day, I'll phrase the question this way. Did anything out of the usual happen in the late morning, early afternoon of that day? What happened?
Almost robbed that company.
I want to walk backwards a little bit. When you say robbed at gunpoint, was this by an individual, a group of individuals? Who robbed you?
Just one.
When did that person arrive at the bank?
Exactly.
Do you know when you first saw that individual in the bank? Was there anything about the individual that drew your attention to them before the robbery?
Person was covered. Was that
When you say covered besides the eyes, what do you mean?
Yeah.
Okay. And is there a photo up there? Oh. If you take a look at what's been admitted as People's Exhibit number 2, do you recognize who's in that photograph?
Yes.
Who is that?
Okay.
What did that person do when they entered the bank before the robbery?
Something I couldn't really see what the person was going. Something.
What happened then?
After that, they came into the branch and came up to my window where the customer was standing and pulled out the gun and said,
Do you know what type of gun this was? Was it a long gun or like a hand gun? Do you know if that gun was loaded? Did they ever point the gun at you or anyone else? Who did they point the gun at? Did they point the gun at anyone else? Okay. Is there any cameras set up inside the bank that records what's going on in the bank?
Yes.
Do you know if any of those cameras captured this incident?
I'm sure.
If you were to see some of that footage, would you be able to recognize it? We can put me up and I'm going to put up what's going to be marked as People's Proposed Exhibit 1 for authentication purposes. I'm sort of stopped here about 1 second in once it comes up. There we go. Ma'am, do you recognize this video? Or do you recognize what's in this video? How do you recognize it?
Station where I normally work.
And have you seen this video prior to testifying? And is this video a fair and accurate representation of what happened during this robbery? I move to admit with the Marxist People's Proposed Exhibit 1.
No, Judge. No objection. Exhibit 1 is admitted.
Permission to publish?
Yes.
And for the record, this is a 9-second long video. I'm starting at the 1 second mark. I'm just going to play it through. Thank you. We can take me off, please. How did you feel? What was going through your head when this individual told you that you were visible?
I was scared.
Did you do anything in response to being told that you were being robbed? Who else was around when this was happening? Do you know if that person yelled anything? What did they yell? In the video, we see the individual walk off the frame of the camera. What happened after that point?
He ran up.
Do you know where that individual ran to?
To the left of the building and
Was this individual able to actually get any money from the bank? Do you know if you saw them take anything from the bank? Were you injured in any way? If I may have 1 second, please, Your Honor.
Go ahead.
That's the witness, Your Honor.
Cross-examination.
Thank you, Your Honor.
Good morning, Ms. Roberts. My name is Alex Warren Green. I represent Mr. Zimmerman in this case. Ms. Roberts, in this case, you completed a standard suspect description form that was provided by the bank you work for, right? Okay. You were not asked by the police to do a photo identification or an in-person identification in this case, were you? Okay. Your recall is that the suspect was 5'9".
I don't know.
Okay. Do you remember putting that on the suspect description form I referenced earlier? Okay. Would it refresh your recollection to take a look at that? Okay, Your Honor, may I approach with the... And Ms. Roberts, just let me know if that refreshes your recall. Would you agree that you at least noted the suspect was 5'9"?
Right.
Okay, so that was an approximation. You also noted that he was in his mid-50s, right?
Yes.
Okay. You did not indicate the suspect's eye color in that report, did you?
No.
Okay. Your Honor, if I may retrieve that report.
Right.
Thank you. Ms. Roberts, the exhibit that was admitted as People's 2 is still in front of you, the photograph, right? Okay. You'd agree with me from that photograph, you can't tell what eye color that person has, right?
No.
They don't appear to be blue, do they?
No.
And they appear to be dark. Would you agree with that? Okay. The video that the prosecutor showed you on your direct examination, that was your entire interaction with the suspect at the register. Is that accurate?
Yeah.
Okay. And from the time the suspect ran out of the branch to the time the police arrived, you'd agree that was about 3 minutes, right?
No, I don't recall.
Okay. Do you remember it being longer by any significant amount?
I don't recall.
Okay. All right. Your Honor, I have nothing further at this time.
I just have one question. You came up with a height of 5'9". Are there doorways that are marked with height? So that was your estimation as best you could. Okay. I just wanted to make sure. Go ahead. Any?
No regret.
All right, ma'am. Thank you very much. You may step down. Okay, why don't we, because I'm going to have to do something. So why don't we take a break in this event and let me see what else I can clear out of the way and then we'll continue. All right. Thank you. You can take him back. Court to pass this matter. We have this.
The forces and some. Mr. Mueller, the case.
It's your way. Okay. Well, I'll tell you what, I'm going to take a break, then come back and we'll do.
Mr. Hill, if I allow this substitution of lawyers, I'm giving you dates today. And proceed at your own peril because I will not permit you to withdraw. This has been going on for 2 months.
Understood, Your Honor.
Ridiculous.
Yes, Your Honor. Thank you. If I could just make a record, Your Honor, I'm concerned that this is a tactic to delay.
Well, it's not going to be delayed any longer because we're picking a date today.
Understood. Thank you, Your Honor.
Adjourn that. Somebody will have to be deathly ill for me to adjourn the next preliminary exam date that I'm going to schedule.
Thank you, Your Honor.
I promise everybody that. So we're going to get out our calendars and we're going to make sure everybody's available. Nobody has to attend a carnival or anything at that time. And we're going to proceed.
Thank you, Your Honor.
So, in fairness, Mr. Hill, I'm not going to penalize you in any way. I want you to be able to be prepared. I want her to have a fair hearing and a fair trial. So I will go ahead and I'm going to sign your substitution of attorneys. This is what you want, correct, ma'am? You want Mr. Hill to represent you. Is that true?
Yes, Your Honor.
And Mr. Perlman, you wish to withdraw. Is that true?
Yes, Judge.
And Mr. Hill, you wish to represent Ms. Calgar. Is that true?
That's true, Your Honor. We're looking forward to moving this case forward.
I don't even think I need to hear your motion withdraw. You both filed a consent for substitution. I'm going to go ahead and sign that order. You're free to go, Mr. Perlman. Now listen to me. I don't go this long. I don't do this. I don't wait 11 weeks to have a preliminary examination. That's what we're at. We're at 8 or 9. And now I've got to schedule this because I want Mr. Hill to be prepared. So my idea is we schedule it for a probable cause conference next week when you guys are available. Ms. Cahalan, if you're available next Tuesday, and you're available next Tuesday, Mr. Hill. If not, I'm going to pick another day next week. And then I will not be here the week of July the 2nd. But I will be here. I'm sorry, I won't be here. I won't be here the week of July the 6th. So we will set the preliminary examination and it will be a drop dead date to be heard the week of July the 13th, whenever you two are available. So, Ms. Cahalan.
Yes.
And Mr. Hill, are you both available next Tuesday?
That would be the 30th, correct, Your Honor?
Correct.
I am available if we can do this first thing in the morning, Your Honor.
Mr. Hill, are you available June the 30th for a PCC at 8:30 in the morning?
I have in-person in Flint, but not until 10:30. If it was on Zoom, absolutely.
8:30 in the morning. You can both be on Zoom for that. Now, let's go to the preliminary exam. Preliminary exam will be July. Lisa, you're going to have to help me. I don't need to do the 14th. I could do the 13th in the afternoon, 15th in the afternoon. I will make myself available.
The 14th would be better for the people, Your Honor.
Are you good with that date, Mr. Hill?
I have kind of a bigger court hearing at 1 o'clock, so I'm worried if it did take longer, it wouldn't work. The 13th and the 15th, I do have flexibility. However, if the people are able to choose one of those 2 days.
Are you good on either the 13th or 15th, Ms. Galen?
I can make it work on the 15th, Your Honor.
Judge, the
Lisa,
15th is a Wednesday.
And do I have anything on that afternoon, like at 1 o'clock?
No, we usually don't schedule the afternoons on Wednesdays.
So I'll do preliminary exam if you guys are both available, July 15th at 1 p.m.
That works for the people, Your Honor.
And that work for you, Mr. Hill?
It does, Your Honor. We appreciate that.
Ms. Cowger, I'm telling
Yes, Your
you,
Honor.
I'm proceeding on these days. Do
Yes,
we
Your Honor,
understand one another? Now, I've gone out of my way. I will not go out of my way again. I'll see you guys next week. Thank you very much. Have
Thank
a
you,
good
Your Honor.
day.
Thank you, Your Honor. Talk to you soon.
You have anything ready?
I'm ready, Judge, for one matter.
Okay,
Thank you, sir.
no problem.
Thank you so much.
Appreciate your help.
No, thank you for what you did.
Aiden Carter Riddell, 26P12600 A, B, and C. I'm curious, Lisa. Oh, I go right. I'm sorry.
Good morning, Judge. John Watson, on behalf of Aiden Riddell. Please, state your name. Aiden Riddell.
Hey, you're speaking up.
You're on.
He's going to speak to allowing, he's going to plead to allowing unlicensed driver to drive. They're going to dismiss the original charge of no ops.
That's correct.
And they're going to dismiss seatbelt violation and obstructive vision. True?
That's correct, Judge.
Is that what you want to do, sir?
Sir.
If you plead guilty to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. There's 0 points, and it won't get reported on your traffic record. Do you understand that?
Yeah.
And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Sir.
All right. To the charge, allowing an unlicensed driver to drive. How do you plead? Were you in control of a 2020, I think, Nissan that was being operated on June 4th, 26 at 12:09 p.m. on Metro Park Drive near the office there in Brownstown Township? And were you unlicensed or suspended or revoked at the time? Nice and loud.
Yeah. Yes, sir. Didn't have the license. And not visible.
Speak nice and loud for me. Were you licensed at the time, but you just didn't have it with you?
Yes, sir.
Okay. Are you on probation or parole?
No.
Is that the only reason they wrote him? He didn't have the license?
Judge, that what happened is he was stopped because it appears because of the tinted windows. It unfortunately but this young man is from Flint, lives in a nice neighborhood because of the problems that exist in the surrounding areas. He has tinted windows. I've indicated that he's got it.
All right. But it just didn't have his license.
That is correct, Chief.
He had a valid license otherwise.
That is correct.
Why are you driving around without a license?
I'm 2 hours away from home. I've been staying down. I'm on that. He's construction.
I know, but didn't you bring your license with you?
No, I did not.
Anybody force you to plead guilty?
No.
You're not on probation. Parole. Please accept it.
Chuck, I just
No ops is dismissed, the speed's dismissed, the seatbelt's dismissed, and the window tint's dismissed. I'm gonna go buddy.
Thank you, Chuck. I appreciate it.
I gotta charge him the 75 and 50. Seems like a nice kid.
He's a hardworking construction worker, concrete finisher, wants to get more education. He's a very ambitious, hardworking guy who puts in a lot of these kids his age don't even do any.
Good for you.
60
Put a
hours.
gold star on your forehead. What are you, 22?
Yeah,
You just turned 22.
he's going to be 22, not 22, end of October.
Oh, I'm sorry. Yeah, okay. I was looking. Geez, we and I share a birthday. We don't need to say the day. I mean, just birth, the birthday, not the birth year. You got me by a few decades. Younger. All right. 10 fines, 10 costs. Did I let you finish?
Judge, I'm very happy.
75 victims' rights I have to charge in $50 justice assessment, 145 or 30 days. Go down the hall, take.
Not to pay that? Can you give him 2 weeks of pay?
You pay in 2 weeks, okay? July the 7th. If you need more time, don't worry about it. Call the court. We'll go on Zoom. I'll give you an extension, okay?
Judge, thanks for the mercy.
No problem. Good luck to you. Do I have anything else in here ready?
Yeah.
All right. Thank you. Everybody stay seated. When I get something else, I'll come out.
But yeah, I do see.
Oh, we're in. We got to do it.
Advice on 46. So we need to build tunnel out too.
So not to be weird, but
Where do you want him around? Just in a jury box?
Yeah. We have all the files from you.
Yes, Judge.
Did you obtain a release?
Correct, John.
Where's Mr. Perlman? Is he out there anywhere, Lisa?
Yes, he already spoke with his client in a breakout room.
What is it? John comes in, give it to John.
Yes.
Come on up here with you.
Those were recommendations, Judge. We'll put that on.
Jeffrey Scott Vance.
Come on up.
267-703-966.
Thank you very much, Your Honor. Good morning, William Mays.
Call him as a smile for me.
Yeah.
William Mays on behalf of.
Mr. Vance. Mr. Vance, state your name. Jeffrey Vance. So Gary has insisted that he include all his recommendations as recommendations, which the prosecutor and I know and understand are not binding on this court and won't be followed by this court. And Gary said as much, but he insists on putting it in there nonetheless.
Wait a minute. Where's Miss Esmar? Get her out here, Luga. Prosecutor. Now, this does not sound like a recommendation. It means listen to me. I've been covering this with them for the longest time. Mrs. Smile, your name?
Of course, Your Honor, Martinez, on behalf of the people. I did speak to Gary about this plea. He doesn't know that in 33rd district, there are recommendations, or they are taking his recommendations.
I don't like this. I can live with the rest. If the defendant is terminated from sobriety or specialty court due to continued program violations, or the judge finds sufficient cause to terminate probation due to a continued violations, there's a little bit of a misprint there. then the balance of the year must be served in jail.
Would you like me to add by the court's discretion, they feel the need?
I don't even know why we need that in there.
I can take that part out.
Please, because I've had people struggle and they do really well, and then they get to the end of the program and they screw up, and I can't graduate them, so I have to terminate them, and it's not fair for me to give them a whole year in jail. That's the big.
Can we just stipulate that you could draw a line right through that entire sentence, Judge?
You guys do it. I want you to do it.
All right.
And I want you to understand something, sir. Before we go on. Here, I'm going to hand you this. And it's going to be a plea to attempted fleeing and eluding fourth.
Yes.
And operating while intoxicated second offense, right?
Yes.
Is that right?
Yes, with the high VAC.
With a high VAC?
Yes.
Well, it's either high VAC or second. Those are two different.
That's correct, Your Honor, I guess then.
Yeah.
Yeah, and that would seem notice.
So what do you want me to do? You want me to take attempted plea elude fourth, which is a 1 year. And then you want me to take it to OWI second or OWI high VAC?
It would be OWI second, and I was told on there that it would be high VAC.
Whatever you guys want.
We'll go talk to him.
Okay, why don't you do that and I'll take the rest of these right now. But strike that out, please, and make it clear that those are recommendations, all right? Okay, let me take, Mr. Perlman, is he out there?
Yes, he's on Zoom.
All right. Which one do you have, Mr. Perlman?
Mr. Adams, he's in custody.
Oh, all right, I'm going to call them all. I have people against Lucas Charles Poindexter. When I call your name, you can come up to the podium. This is file number 26W841852. I have Colton Lewis Smith, 26W842735. I have Giovanni Joseph Wilczewski, 26W841855. And I have Jiden Armani Adams, 26W842737A and B. All right. Why don't you get these guys on one side or the other? Are you Mr. Poindexter? Yes? Yes, sir. Wait a minute. Let's slow down. Can you turn that podium to me? Thank you. Mr. Poindexter, your name. What's your name, sir?
Colton Smith.
What's your name?
My name is Chesky.
Your appearance?
Good morning, Your Honor. Mr. Shanky, on behalf of these three clients, Your Honor, we did have an opportunity to speak with them.
Wait 1 second. I want to get Mr. Perlman's appearance, please.
Good morning, Judge. Jeff Perlman on behalf of Mr. Adams.
Mr. Adams?
Yes, sir.
Your name?
Don Adams.
All right. So you have two files. Okay, so let's just take these three gentlemen first of all. What are they going to do?
First, I have a housekeeping issue.
And Detective Cern, I need your name. My apology.
Yes, Your Honor. Detective Cerno with the Wood AM Police Department.
Yeah, I know conflict representing these two individuals at the arraignment. I did check with them. They had no issue with me handling their arraignments. That being said, I asked to all three waive formal my client was staying here.
All right, so I'm entering not guilty pleas for each one of you. And it says, McDonald's employees did not want on property. Was told to leave, was there to harass the subject, took camera and went in to harass Joseph Lucrecio. Were they all in there doing that allegedly, Detective?
Yes, Your Honor.
So this was at a McDonald's?
Yes, Your Honor.
So I'm entering not guilty pleas, indicating that every one of them stand mute. I have not gotten yet to Mr. Adams. All right, I'm gonna need you to fill out 4 different button sheets for me, please. Here you go. I got it. Okay. All right, just put the names on there. So Gentlemen, you have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. You have the right to be represented by a lawyer at all subsequent court proceedings. If you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that, Mr. Poindexter?
Yes, sir.
Mr. Smith?
Yes, sir.
How about you, Mr. Wazowski?
Sir.
All right, Mr. Perlman, for purposes of arraignment, how does your client wish to proceed?
For purposes of arraignment, Judge, my client would enter not guilty, please stand mute and waive formal reading of the information.
I will enter not guilty pleas for him. Indicate that he stands mute on both the disturb the peace as well as the stalking charge. What can you add about that, Detective Cerna? You only charge him under local ordinance though, right?
Yes, Your Honor. Yes, regarding the stalking charge, he made numerous unwanted contacts with Joseph Lucrecio throughout the day, and officers responded to multiple calls regarding this throughout the day.
Where does your client live at, Mr. Perlman?
Judge, my client lives in Texas. He has no criminal record. He had a right to be where he was, where this other gentleman was as well. But you know, he's not a flight risk. This is not obviously an assaultive offense. And you know, in terms of the you know, the nature of the allegations, I mean, my client maintains his innocence, but we would ask for a personal bond.
What are you asking for?
Yeah, all three of my clients recently graduated from high school, 2026. At least one of them is gainfully employed. The other two were dishwashers, but they're not employed anymore. However, Judge, they all have a strong family support system. They're not on probation parole. They have no priors. I would ask for a personal bond.
Detective Cerna, what are you asking for?
Your Honor, I'd like to, I'm asking the court to give some type of cash bond. Yesterday, I said the officers on the road had about approximately 3 calls come in regarding these gentlemen here causing some type of disturbance. So therefore, I'm asking for a cash bond.
Where do you guys, so Mr. Poindexter, you live in Rockwood?
Yes, sir.
Where do you live, Mr. Smith?
Brownstown.
How about you, sir?
I live in Rockwood.
You know how these guys hooked up with Mr. Adams here? I'm asking you, Detective, do you know? He's from Texas and they're from...
I believe Mr. Adams is a social media online streamer. I believe these 3 gentlemen here saw his stream and wanted to meet up where he was streaming at regarding him following around this Joseph Crucio throughout the city of Woodhaven.
What kind of contacts did he have that would justify a stalking charge? Mr. Adams, I'm talking about.
Yeah, he was Joe was at the McDonald's in the morning. Then they followed him back to his house shortly after. I know the officers transported Joe to the police station to get away from this Adams and his group of people. And they walked into our station lobby asking for him. And then the officers took him back to McDonald's, and the group here followed him back there again.
Your Honor, if I may,
Sure.
My client has actually a contract from the owner of the residence allowing him to be at that residence. The complainant, he was squatting at that residence. My client was lawfully in that residence. Furthermore, he was at a McDonald's, and when he was asked to leave the property, he left the property. That's it. There was no stalking. The first time this person ever encountered my client was yesterday. My client had permission to be there from the owner, as opposed to the complainant who did not have permission to be there. So
They're just charged under local ordinance, just so as you know, that's just a 90 or 93-day misdemeanor. It's not the 1 year, but I'm not necessarily disagreeing. I don't know enough about the case. How much does your client make, Mr. Perlman, and whatever he does for a living?
Your Honor, I don't have that specific number at this time. I would just indicate that he is a public YouTube presence, which requires him to maintain his reputation and again resolve this legal matter. He's not a flight risk. His public identity is built on accountability and transparency. He live streams his activities and operates openly with law enforcement agencies across the country. In fact, the incident is available on YouTube right now. There's complete transparency. Again, this is not an assaultive offense. First time my client ever encountered this person was yesterday. He has the means to travel and the means to return, and the court can be assured, and he's retained counsel, and the court can be assured of his appearance through the standard conditions. And we're asking for a personal bond and that he be able to travel as required for his work. He's not a danger to the community. He's in fact assisted in the arrest and prosecution of dozens of people across multiple states in cooperation with law enforcement. So we're respectfully asking for a personal bond, Judge.
Mr. Poindexter, Mr. Wilczewski, and Mr. Smith, I'm going to give you a personal bond of $500. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to enter or go near 22172 West Road in the city of Woodhaven. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to have any contact, no contact whatsoever with Joseph Lucrecio. You understand that? You cannot write, phone, see, text, email him. You cannot have anybody else do any of those things for you on your behalf. Do you understand that, Mr. Poindexter? Sir. Do you understand that, Mr. Smith? And do you understand that, Mr. Wojcicki? Sir. I'm going to set the bond on the stalking case. I'll give you a $10,000 personal bond. You can leave the state without the consent of the court. Mr. Adams, you cannot violate a law. You must appear in court as directed. I'm telling you, no contact at all with this Joseph Lucrecio. You cannot write, phone, see, text, email him. You cannot go back to 22172 West Road in Woodhaven. No contact with prosecution witnesses. Again, no contact with Mr. Lucrecio. You cannot have any contact with prosecution witnesses except through your lawyer. Has he been printed on this yet? Detective Cerna?
I'm sorry, was that Your Honor?
Has he been printed and photographed on this charge?
Yes, Your Honor.
All right, so you've already been printed and photographed, so I'm not going to order you to do that. But no contact with Joseph Lucrecio, no contact with prosecution witnesses. You cannot enter 22172 West Road, Woodhaven. I will let you Zoom for pretrials. The rest of you gentlemen. Hang on one second. Yes. The rest of you gentlemen, you're going to have to appear here, okay? Unless you retain a lawyer. Go ahead. What's your question?
When we have to leave the contract to be at the house.
I don't want to talk about that. If you want to talk to your lawyer, that's a legal question. You can ask him.
Okay.
Okay.
So.
Judge, may I address, and I apologize, may I address, there also the law enforcement has seized my client's camera equipment, which is about $120,000 worth of equipment. There's absolutely no need for them to have that. Everything that occurred yesterday pertinent to this investigation is available online. I'm sure they have access to it. I'm sure they've saved it, but there's absolutely no reason for them to keep the camera equipment, which is, again, my client's livelihood and valued at approximately $120,000.
Here's what I think the appropriate remedy is at this point. I'll give you the earliest possible court date that you want. You can talk to the Woodhaven city attorney and explain your position. And if he disagrees, you can file a motion and I will hear it on the first court date. Okay. I don't know why they would be preserving that unless if there's some, that has some evidentiary value. I'll say that, but I'm not going to willy-nilly go ahead off the cuff and order anything, any return of anything right now. I'll give you a pretrial date. When do you want to, what day do you want to have this pretrial? I can give you, can we do it earlier than July 27th?
There is an afternoon docket on July 13th.
What did I have with Brownstown? I mean, with Woodhaven?
Yes.
So let's do it July 13th at 1 PM for everybody, okay? July 13th at 1 PM. And again, I would encourage you to call Mr. Urick. If he doesn't agree to the return, then you can file a motion and I'll hear it on July 13th, okay?
Okay, thank you, Judge.
So anybody have any questions? Mr. Poindexter, Mr. Smith, Mr. Wilczewski. Anything else, Mr. Shen?
No, Your Honor.
Anything else from you, Mr. Perlman?
No, Judge.
And you heard what I just told your lawyer, right, sir?
Like asking the questions about.
Well, you heard what I just said about the camera equipment.
Oh, yes,
Okay. So we'll let it go with that. And I'll give you guys an early court date of July 13th at 1. And if somebody wants to file a motion because the prosecutor doesn't agree to it, I'd be glad to entertain it at that time. Okay?
Yes, I believe my client has a question. I have no problem with it.
What's your question?
Like I was saying, I am residing at the address you gave, is that the address of McDonald's or?
Yes.
Okay.
22172.
So I live in the house, not that McDonald's, but I live in the house.
What house?
Joseph is illegally residing in, squatting inside of. I did sign a contract with the homeowner to live there. And that
Where's that at?
That is, it's like about 3 minutes from the McDonald's. Like I moved in, all my equipment's there.
Wait a minute, slow down.
Yes, sir.
You're telling me you're living in the same house as Mr. Lucrecio?
Well, he doesn't live there legally. He's.
I don't care. Is he living there?
Yes, he is living there.
You cannot have any contact with him. So you're gonna have to find another place. If you're gonna run into him by going back to that property address, you're not gonna have any contact with him, sir. You're gonna have to go elsewhere. Do you understand that?
Okay. The court provide anything or?
Well, Judge, I guess the concern and what the issue is that my clients are, bringing to the court is that my client has a legal right to be there and this person does not have a legal right to be there.
Like, how do you want me to decide that now? Now, wait a second. Hang on. You're telling me that. How am I supposed to determine that now, Mr. Perlman? Because you tell me and your client tells me that he's squatting and he's illegally there. I don't have any authority. I understand that, Judge. Involved and witnesses involved and police involved. And do you know anything about that, Detective Cerna? Is this gentleman a squatter, Mr. Lucrecio?
From my understanding, Your Honor, he is being evicted on this Friday. I haven't seen any eviction paperwork or anything. That's just what I was told from the officers at the time ago.
Is it before this court pending?
I'm sorry, Your Honor.
It's got to be in this court, right? In this 33rd District Court, that landlord-tenant action?
Yes.
Well, I mean, guys, I'm just telling you, as of now, Mr. Adams is not going to have any contact with Mr. Lucrecio. Now, if Mr. Lucrecio is evicted before the next court date, I'll be glad to change my mind. But but I'm not going to sit here and make findings that the guy's a squatter or anything. I don't know anything about that. Maybe it was in front of me, maybe it wasn't. I don't know. I handle cases every day, but I'm telling you, you're not going back there if he's there. Do we understand one another?
If he's there, yes, sir.
Sir, don't go back to that house.
Okay.
If you go back to that house and he ends up there, you are not going to like what I'm going to do. I promise you that.
No, sir.
You're going to be sitting in jail a long time awaiting bond or awaiting trial.
Yes,
okay. Sir. I'm going out of my way. You're out of state. I gave you a personal bond on a stalking charge. Don't tempt fate. Okay. Good luck.
Thank you, Judge.
Thank you. Thanks.
Thank you, Your Honor.
All right, Jeffrey Scott Vance, are we ready on that?
Yes.
26F703966.
You should have the amended agreement.
All right,
That's over by the prosecutor, Your Honor.
let me see then. You guys give me a second here, please. I don't think I have it again. Do I? Did they hand it to you?
The email, because we don't have a printer.
They may have sent it to me. Let me check. No, I don't have anything.
Hold on.
What did you email them?
Didn't find it. Sorry, Judge. I guess I don't understand. She's emailing it now.
Okay. Well, listen,
Yeah.
it'll take a minute, so I'll have them printed out and I'll come right
Yeah.
out, okay? Okay, good enough. Stay, you can be seated until I get it. Thanks, sir.
Excellent.
Do you know what this is? So we put on my desk.
Airspace. Who's in here? Get this one out of the way. Court does call the case, People versus Brianna Force.
No, are you ready?
Good morning, Your Honor. Wendy Barnwell, P425. On behalf of Ms. Force.
Hello, Miss Force. All right, what are we doing?
Or see this.
Your Honor, we would respectfully move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion without. All right,
Yeah.
thank you.
Thank you, Your Honor.
Court does call the case, People versus Khalid Ahmad.
Good afternoon, Your Honor. Good morning. Jake.
We need to feel that. Thank you.
Good morning, Your Honor. Robert Mullen on behalf of the defendant.
Sir, can you take your name, please?
Khalid Ahmed.
And my understanding, this a waiver?
Correct, Your Honor.
All right, sir, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by standard of probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing, that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. You acknowledge receipt of the information waiver reading?
I do, Your Honor.
Your client stands muted.
Absolutely.
Defendant every waive form of reading, standing mute. Court will enter a not guilty plea as to all charges. Pretrial in this matter will be set for
August 25th at 1:30 with Judge McNally.
August 25th, 2026, 1:30.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, Your Honor.
Enjoy the rest of your week, Judge.
You do the same, sir. Yes, sir. Is that a threat? It sounded like a threat.
It was a warning.
Okay, all right. All right, well, I'll calm down then. Right. And we're ready for him. I think that's it, right?
So you're 1 p.m.
Okay. People of the state of Michigan versus Kyle Zimmer.
Good afternoon, again, Your Honor. Raymond Cook.
Alex Warren, great on behalf of Mr. Zimmerman. Mr. Zimmerman, could you state your name again? Michael Geddes, both defendants.
All right, thank you. Ready to continue?
We're ready, Your Honor.
All right.
That's ready.
You may call your next witness.
Well, Detective Adam Ondrovic.
See?
Yes.
Sir, please come forward and be sworn.
Take a seat, raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Say swear your first and last name.
Detective Adam, ADAM Ondrovic, ONDROVICK.
Yeah, CK. All right. You may inquire.
Thank you. Good afternoon, Detective. How are you doing? Detective, how are you employed?
I Tecumseh Police Department.
And in what capacity do you work for the Tecumseh Police Department?
Detective first.
How long have you been a detective?
4 years.
Any previous law enforcement experience?
Worked for Tecumseh 12 years. Prior to that, with the Loudoun County Sheriff's Office for 10 years.
So 22 years total, is my math correct?
Yes.
At any point, were you asked to, or let me rephrase this question. Were you ever able to assist into an investigation related to a bank robbery that occurred December 5th of 2025 here in Washtenaw County?
Yes.
How were you able to assist with that investigation?
How I got involved was I was contacted by Carly Zimmerman via text that there was
Objection, Your Honor.
Your Honor, it's not for the truth of the matter asserted.
First state of mind as to what he did. So objections overruled. I'll take it for that.
So I was contacted and I was asked if I knew about the bank robbery. I did know already about the bank robbery because I was working that day. And it was sent out through our law enforcement contacts. And when I reviewed the images that were posted online, I immediately recognized who the was.
And who did you recognize that individual as being?
Kyle Zimmerman.
Do you see that individual in the courtroom here today?
I do.
Can you please point to them and identify them by an article of clothing that they're wearing?
So, to me, my love.
Record may reflect this witness has identified the defendant.
Record shall so reflect without objection.
Sir, do you have a copy of People's Exhibit 2 in front of you by any chance on the counter there? Or have both copies? Because I think there was one.
Probably do. Yes.
Sir, do you recognize People's Exhibit 2?
Yes, that is the photo that saw it.
And is that the individual you were able to recognize as the defendant?
Yes.
How do you know the defendant?
I know Kyle for 45.
And what about that photograph led you to be able to identify the defendant?
The first thing was his eyes. Bridget was nose. I've been on for a long time.
immediately I knew who it was.
You said he was your cousin. Were you two close?
We were younger.
How often would you say you, over the course of knowing the defendant, you interacted with him?
Well, I would say the last 20 years, it's been more in my professional capacity than it has been as a personal or for family.
I guess let me refine the question. Have you interacted with him as an adult or just when you were kids?
No, as an
When was the last time prior to December 5th that you had seen the defendant?
I would probably say at a sporting event where his son, one of our, we have local football games, his son played on our football team, and I went to school resource officer.
When was that?
The year prior to this, so the fall of that summer. I mean, so what this happened this year, or what year was, I guess I could live in it, you know, that was the day, I can't remember.
So prior to December 5th, 2025, when was the last time you had seen the defendant?
I would say it was that fall, so that at a football game.
So it'd been a couple months, am I hearing correctly? So, okay. Did anyone ask you to identify the defendant?
Sister asked me, I would look at.
Did law enforcement reach out to you prior to you reaching out to them about this case? I can have one moment, please, Ron.
Yeah. Witness.
Cross-examination.
Your Honor.
Good afternoon, Detective. My name is Alex Forengreen. I represent Mr. Zimmerman in this case. Detective, on direct examination, you said that Kyle's sister asked you to take a look at the picture. Is that correct?
She asked if I'd seen it.
Okay. Is Kyle's sister a law enforcement officer? So on December 9th, 2025, you left a voicemail for Detective Ross at the Ann Arbor Police Department. How did you did you call him directly?
Detective McNally.
Okay.
I gave the officer in charge's phone number.
And that was after you saw a photo of the suspect in this alleged bank robbery, right?
Correct.
Okay. And you were 99.5% sure that the person in that photo was your cousin, right? Okay. And you said on direct examination, did you say you've known him for 40 years?
45.
Okay. Over 40 years, right? And right.
Yes.
Okay. Another thing you mentioned is Kyle always wears glasses. Is that your recollection?
I have seen him without glasses. I worked in Long County Jail and he didn't always have glasses. I'm married either.
Okay. You remember telling the detective in charge that he always wears his glasses?
Okay.
All right. The picture, is that still in front of you, People's Exhibit 2? Not wearing glasses in that picture. And he is wearing a mask that covers from kind of the tip of the nose and to underneath his chin. Is that accurate? And he's wearing a beanie hat that covers the hair and the eyebrows, right? You know Kyle to have blue eyes, right?
Yes, I mean, I don't know. I would say I would know what his eye color is right off the bat, but.
Okay. You can't conclude from that picture, the person in that picture has blue eyes, right? Okay. Another thing you gave to the detective in charge was contact information for Kyle's dad, right? William Zimmerman?
Yes, I did pass on family members' contact.
You provided information for William Zimmerman. Did you also provide information for Keenan Zimmerman?
Maybe a name. I definitely wouldn't have had any phone numbers. So.
You know a person named Keenan, Keenan Zimmerman, right?
That's his brother.
Okay. You'd agree Keenan is approximately 5'9" tall?
I can't say yes, but I don't know how tall he is.
Okay. When's the last time you saw Keenan?
Long time ago.
A long time,
15 years, probably.
over 15 years. Okay. You know if Keenan's shorter than Kyle?
Last time I saw Keenan, he was probably.
Okay. Your Honor, I have nothing further at this time.
All right.
Thank you, Detective.
Your Honor.
Yes.
Detective, have you ever seen the defendant wear sunglasses where you couldn't see the color of his eyes? Let me phrase it differently. Have you ever seen the defendant without being able to see his eyes? For example, wearing a baseball hat that covers his eyes.
Yeah, I've seen baseball hat before.
Were you able to recognize him without being able to see his eyes then? Nothing further. Thank you, Your Honor.
Your Honor, I have nothing further. All right, thank you. Detective, thank you so much. Thank you. All right, thank you.
I think we'll call William Zimmerman.
All right. Sir, please come forward and be sworn.
Before you take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you about to give the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, have a seat. State and spell your first and last name for them.
William W.I.L.L.Y.M. Zimmerman, Z-I-M-M-E-R-M-A-N. Thank you. You may inquire. Thank you.
Good afternoon, sir. How are you doing?
All right.
Sir, do you know an individual by the name of Kyle Zimmerman?
Sir, my son.
You see that individual in the courtroom today?
I'm seated, sir. And agree to.
The record may reflect this witness has identified the defendant.
The record shows so reflect without objection.
Sir, I want to draw your attention back to December of last year, specifically December 5th of 2025. Do you remember that day?
I believe I know.
Did you have any contact with the defendant on that day?
No.
You receive, or did anyone in your family receive any text messages from the defendant on that day?
Not from the defendant, I didn't. Family members? Yeah, the family members had received, his son received one.
Your Honor, I would object to what the family members received. I don't think there's an adequate foundation as well as hearsay.
Do you know of your own personal knowledge that those text messages were received? Yeah. Okay. I see. Yeah. Overruled. Go ahead.
So you saw some text messages, and those text messages were sent by the defendant?
Yes.
Do you remember what those text messages said?
They stated about, so he'd done something really stupid or crazy. I believe he used the phrase crazy, and that he was, and then his life was over, and he was ready to want to know if the children do anything, anybody that may needed to be disposed of, I believe.
One second, please, Your Honor. Pass the witness, Your Honor.
Cross-examination.
Your Honor.
Good afternoon, Mr. Zimmerman. My name is Alex Warren Green. I represent Kyle Zimmerman in this case. Mr. Zimmerman, on your direct testimony, you told us that you had knowledge of text messages that were received by a family member. Okay, and none of those text messages said, I committed a bank robbery or an armed robbery, did they? Being Kyle's father, you know Kyle to have blue eyes, right?
Blue eyes?
Yes.
I don't know the color of his eyes. I haven't seen him that close recently. That's in green or blue, somewhere in it.
Okay. And Kyle has a brother, Keenan, right? Okay. Keenan is shorter than Kyle, is that accurate? Okay. About how tall is Keenan?
5'8".
Okay. I'm sorry, you said 5'7", 5'8" range. Okay.
At least probably 6 inches short.
Okay. Your Honor, I have nothing further at this time.
Can you redirect?
No, Your Honor.
Sir, you may step down. Thank you.
People have no further witnesses and rest at this time.
Any witnesses for the defense?
No witnesses from the defense. The defense would arrest you then.
All right. Go ahead.
People would move for bind over on an amended information, that being work counts as charged as well as an added count 5 of bank robbery, that being contrary to MCL 750.531, as well as felony firearm for that bank robbery, that being contrary to MCL 750.227.
750227.
227B. Yes.
227B. And what was the first pack?
The bank robbery pack was 750.531.
531. All right.
Your Honor, the court heard testimony today, and I guess in an alternative, because I believe there may be an argument about the armed robbery. I would also argue if the court is not inclined to bind over an armed robbery, that the court could bind over on an added count 7 of assault with intent to rob while armed. As there was a question about whether, well, no property was taken, but I believe there's a question about whether or not an actual taking is required for armed robbery. Regardless, I think the people have proven primarily the armed robbery, that being that the defendant went into this bank with a gun. I believe the testimony said he said something along the lines of, give me the money or this is a holdup. And certainly that put both the teller as well as Ms. Hoff, just the bank patron, in fear. The felony firearm, of course, going along with the felonious assault, going along with the armed robbery. And there was a stipulation to the previous felony that would make him ineligible to possess a firearm. So I believe people have proven count 2 as well. And this happened at a bank, which is what gives cause for the added count 5, and then the felony being, or the felony firearm there being, again, use of a weapon or of a firearm during that bank robbery. I reserve the rest of my argument for rebuttal and move the court bind over on the amended information, adding those counts 5 and 6.
Right. Your Honor, the defense would object to bind over. In making the bind over determination, I'd ask the court to consider the competency of the testimony with specific respect to identification of this defendant as the suspect in the alleged robbery. I'd also ask the court to consider, with respect to what is charged as count 2, felon in possession of a firearm, the people do not need to show that a firearm is operable, but they do have to show some evidence that it was in fact a firearm defined as a weapon designed or intended to propel a dangerous projectile by explosive gas or air. Your Honor, I'd ask the court to consider the lack of testimony we have with respect to the design and construction of what is alleged to be a firearm in this case.
Well, I saw it, and so wouldn't that really be a question of fact?
I'd ask the court to consider it in making the bind over decision, just based on the weight of the evidence at examination.
Wasn't an answer, but wouldn't, go ahead, counsel.
Thank you, Your Honor. That's really all I have with respect to what I'd ask the court to consider at this juncture. I think identification is the number one thing that we'd ask the court to consider, followed by what is alleged to be a firearm. Just the weight of the evidence on that, I think, goes to certainly count 2, but I'd also ask the court to consider it in count 1, armed robbery, and the added count.
So for purposes of preliminary examination, if I, as to the issue of identification, a 99.5% by the individual's first cousin isn't enough for bind over, is what you're indicating?
We'd ask if the court's inclined to bind over, that it be over our objection.
It's always the case, but go ahead.
Your Honor, I have nothing further at this time. Those are the considerations we'd ask the court to make.
All right. Thank you. Anything additional from the people?
Your Honor, I don't think there's much else to add. The court pointed out the witness, who has known the defendant for decades, said with 99.5% certainty, the individual that was in the photograph that was on video committing this offense was the defendant. I would again move the court to bind over on the amended information.
All right. Court's going to take a brief. I'll come back and give you my decision.
All right.
What do we have? 5 cases on Taylor Jackson, right? 5 cases, right? What are we gonna do? Oh, you're working on that? Yes, sir. Jalen Brown.
Sure, Judge, just please.
Thanks.
Please need to come up with the judges for reindictment. They reindicted it last week. I do not have a new file ready, but I did put the new indictment.
Thank you.
Yes, sir. Ms. Brown. Please raise your right hand. Please swear or affirm for the people who have been God. Yes, okay. Have your roll right. I go. Peter. Yes, please. Okay, let's file. You don't want to help? Yes, they go. They go. Yes, ma'am. I just need 2 copies of it. Place it right here, right outside the box. Okay, let's name from the judge.
And 25 CR 1215 is now called the State of Texas versus Jalen Nicole Brown. That's you?
Yes, sir.
President, Ms. McNally, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about July 16th, 2025 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle
in a public place while intoxicated with a child passenger, a child under 15 years of age. This is a state jail felony.
Judge, I believe there's a re-indictment and she's pleading to the re-indictment, not this case specifically. It is right outside the whole statute. So the DWI indictment will be a dismissal with a plea to the new indictment for endangerment of a child.
So we've got two different cases here.
That's correct. They'll both be disposed of today. I just have the file
You
yet.
don't have a file on this? Okay.
No, it's a re-indictment. Re-indicted last week, Judge. I don't have the new file yet.
Okay, then let's jump to 26 CR 1173. And the defendant waives a formal reading of this,
Yes, Judge.
and we proceed in summary.
Yes, Judge.
This was handed up on June 17th.
Last week, Judge.
Okay. Does the defendant waive any additional time that she may have under the law to proceed in this case?
Yes, Judge.
Okay, have you discussed this with your attorney, Ms. Brown?
Yes, ma'am.
All right. And this is what you wish to do is waive any additional time under the law that you may have. Since this was filed recently, you do have a little bit of time that you can prepare, but do you feel like you are ready to move forward and you've discussed this with your attorney and that is what you want to do?
Yes, sir.
All right. In 26 CR 1173, in summary,
Yes, Judge.
this indictment states that on or about July 16th, 2025 in Jefferson County, Texas, which was the same date as the prior event. In Jefferson County, Texas, you committed the state jail felony of abandoning. It's the statute is abandoning or endangering a child, but in the charging instrument, this says you acted with intentional, knowing, recklessly, or with criminal negligence, placed a child in danger by operating a motor vehicle while intoxicated and failing to secure the child in a seat belt. And you did not voluntarily deliver the child to a designated emergency info provider. So was there an accident?
No, Judge.
Why is this? And the defendant did not voluntarily deliver the child to a designated emergency infant care provider under section 262.302. What's that all about? Why would that be? Reckless and engaging conduct by operating a motor vehicle while intoxicated and failing to secure the child in a seatbelt and did not voluntarily deliver the child to a designated emergency infant care provider. What happened on that? What's that all about?
But she was just pulled over in an accident. There wasn't an accident. She was just pulled over. Unless my memory is
I mean, is that a necessary element of the offense, though, that's been alleged or not? I don't get these a lot. See if everyone. This says section 22.041F, offense code 3899. I mean, there's no referral or in the indictment to what code that is referring to. I don't think it's the penal code. Yeah. But it is. Yeah.
Okay, yeah. Right. Yeah.
Yeah. It was already alleged.
They brought her back in.
Just ending with place.
Okay, and she took her boots tied.
Imminent danger. That voluntary.
So,
That's an attachment.
yeah, I really good. Should see you want to. Never question what very. Let's see, but yeah, go ahead. I'm only.
But I think that we can probably just abandon that sentence.
I don't know, can we?
Under section 22.041 H, it states that it's an exception of the application of this section if the child is voluntarily delivered to a designated emergency infant care provider. So I think the indictment is just alleging that she did not do that, so the exception doesn't apply. Section 22.041 H. It's an exception to the general rule. I believe we can just abandon that because that's not applicable in this case. She did not deliver the child to anyone, so the exception doesn't apply, but I don't think we need to have it in the wording of the indictment to be able to charge her with this offense.
Well, I don't know if that's, I think, as I'm reading this, maybe it needs to be in there.
Okay, I don't think it changes
It
what
says
was
it's an
left.
exception. So. But by stating did not deliver, then it.
The exception doesn't apply.
Section 22.041 applies. I think.
I don't know if it changes.
I don't think it does. Let's just keep it the way it is. I don't know what's the. So this is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty and not found guilty. You will be placed on deferred or unadjudicated probation, which can be up to 5 years in length. Fine $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as States Exhibit 1. Did you sign that document?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct? Yes. Okay, you have to speak out to teaching theory here.
Oh, okay. Yes.
States Exhibit 1 is tendered in full without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictment's been read to you. You read it. You're guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
Nothing further. I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But the court is going to instead defer or postpone any findings of guilt so long as you follow these terms and conditions of probation. Make sure you do. You will be placed on deferred or unadjudicated probation for 5 years. If you fail to follow these properly, your probation could be revoked. You could then be found guilty and a sentence up to the full range of punishment, up to 2 years in the state jail. And that would be a felony conviction. Have you ever had a felony conviction? You don't want one. It closes off a lot of doors of opportunity. Anything else on this? Okay, please see the probation officer.
And Judge, the opinion case will be dismissed, but paperwork has not been sent over by the state yet.
Sorry.
There's going to be a dismissal on the other case. It just hasn't been sent over by the state yet. Thank you, Judge.
Thank you. Ricardo Kelly.
Oh, ready on. And tell me, there's so many there.
There's 20 Mr. Kelly.
Yeah.
Helen, Mr. Elkins. Please raise your right hand. You swear or affirm to have the truth and the nothing but the truth, nothing but right now, please. Please, flat right there involved. You get everything about it.
Mr. Kelly.
Twenty-three CR 2261 is called. Ricardo Kelly, that is you? Yes. Present with Mr. Adams, your attorney and the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. And can we proceed in summary?
Yes.
In summary, this indictment, sir, which was handed up by the grand jury on December 13th, 2023, alleges that on or about August 31st, 2023, in Jefferson County, Texas, you committed for the state jail felony of theft of services involving a Mazda automobile under some kind of a rental agreement that because I guess violated C. And do you understand what you're charged with here? If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. Additional, you may be assessed a fine not to exceed $10,000. Do you understand? The agreement's been reached in the case you'll be pleading guilty and sentenced to 2 years in the state jail. That would be suspended. You would be placed on 5 years regular probation. And there's restitution here in the amount of $24,282.
Yes, Judge.
Where'd the car go? Was it wrecked or something or what?
Well, it hadn't been returned.
Where is it?
He doesn't know where it is.
You don't know where it is?
No.
I'm asking you.
As I explained before.
Let's play like I don't have 5,000 cases. Tell me, what did you explain before to me?
I explained that I rented the car for a friend, and the friend didn't do right with the car. Now the car is missing. I don't know where it is. I've been trying to find it. So it's no point in me trying to get him to come to court to try to help me with this. So I'm willing to take my probation and get it out the way.
Judge, this has been reset several times for us to be able to find the car. The car hasn't been found.
What are y'all going to do with the quotes friend who's sticking it to him?
I actually went to the police station yesterday to talk to someone. I did talk to a sergeant. He did state that if I was able to come up with the information about the car, he would look the car up just to see if the guy, just to prove that the guy was the last person that had the car, possession of the car. So
As of now, our office doesn't have any additional cases regarding this car.
Are you going to pay back $24,282?
Just have to work and do what I have to do, sir.
Well, how much are you able to pay?
I don't have nothing right now, so
You don't have a dime you can pay him?
no.
Mhm. Must be nice to be able to not have to pay $24,000 and give a new car back, huh? And then scamper away on probation.
I mean, the point of probation is to pay the car.
No, it's not. That's not the point, sir. No, that's one of the factors. Restitution. You don't even have a plan for restitution. You have nothing to give right now. I mean, this happens a lot up here where people come in, get probation, and then scamper away, and they never pay a dime to the people who are lost, and the people who, I guess it's Avis, are out the money, and they never get the money. Right. What do you do for a living?
Right now, I'm a shift leader at a restaurant.
Okay, and is that a salary or do you get an hourly wage? How much do you get an hour?
$11 an hour.
No, that's 22,000 over a year. So how much are you going to be able, have you thought about a payment plan of how you were going to pay this back, like per month, like a loan?
However, it's one of those, I just have to go from there, but I don't have a plan until it's orchestrated. So once it's orchestrated, then I go from there. I just have to word it.
Okay. You know, when you made the deal with Avis, they made the deal with you. They didn't give you permission to let that car go to anybody else. You know that, don't you? That's like fraud, because you signed a contract saying you were going to take care of it and that it was not going to be re-let to someone else. Well, you violated that contract and then the car is gone.
Why don't you pay whatever was the rental fee per day? Pay that as restitution. Can you afford that? Whatever was the rental fee? That'd be an idea.
All I know is I just do my best and work. I'm already in a situation behind somebody else. I understand I signed my name, but this was the point of trying to help someone, and it messed me up in the end. I'm sitting here admitting that I was wrong for signing my name and letting them use the car.
That's true. But he's got some responsibility too.
He don't want to come in. That's true.
I hope the district attorney's office is looking into that too, because that's kind of, he knows. He's taken something from this man through Avis, and that's kind of like stealing, isn't it?
Yes, Judge, we can follow up on that.
That's theft. And there's no reason why that person shouldn't be looked into and him be held accountable as well.
If it was me that did something to the car, I would admit and take it, but I didn't do nothing to it but sign off on it.
No, but you loaned it to someone without the authority to do that. You were giving someone else's property, which you shouldn't have done. That's why you're in a mess. And he's in a mess too, because you were responsible and then he betrayed your trust. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Pleading guilty voluntarily because you are guilty. That's a question. Yes or no? Are you pleading guilty because you are guilty?
I'm guilty for signing.
Yeah, that's yes or no.
It's a yes or no.
Yes.
Yeah, guilty, but it doesn't mean it's either guilty or not guilty. Here, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered? No. Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with from madness and read to you. You've read it. You are guilty of the crime charged and any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, it states. So help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
All right, I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended. You were placed on regular probation for 5 years. You must pay restitution to Avis and the complainant in this case in the amount of $24,282. There will be other terms and conditions of probation, which are normal and customary for the circumstances of this case. Also, as a condition of probation, you will fully work with the district attorney's office and law enforcement officials to take all efforts to get that vehicle back. And you will fully cooperate with the authorities. in that regard. Do you understand?
Yeah.
I like that guy. Brought the justice and get in here as soon as possible. Everybody with the state if possible, please.
Yes.
See what you can do about that. All right, anything else? That is all. Please see the probation officer.
Yeah, that's issue.
Okay, I have a dismissal here in Jalen Brown, 25 CR 1215. That case is dismissed in lieu based upon a plea of guilty in another case today.
It's got Keller in the corner.
What are we doing? A Cornish, Corley Cornish? Corley?
I didn't see her this morning.
Corley Cornish is called 24 CR 1949. Dennis, there's no answer here in the courtroom. I asked the bailiff to call into the hall for Corley Cornish, please. And where's Trenton Keller?
He's here, right here.
Come on up, Mr. Keller. What's a bone? There's no response to the name called here in the courtroom and no response to the name called into the hall. Defendant was required to be here based upon the court's last setting order. And she has failed to appear and her bond is
15,000.
The bond is revoked. A warrant shall be issued for her arrest. It is doubled to $30,000. Plus, she must have a GPS device. She must stay at home. She is allowed to leave home to and from in the most direct route possible to work, school, to get food, and to consult with her attorneys. Those are the orders of the court. Trenton Keller, is that you? And 26 CR 640, you are charged with this third-degree felony of evading arrest or detention with a motor vehicle. What are we doing with that?
He's on this. I just want to put him on announcement so I can download Discovery.
Okay, we set for announcement, regular announcement time. Thank you.
All right, just maybe.
All right. I'm sorry. Yes. Court does recall the case of the people, state of Michigan versus Stiles and Willing.
Good afternoon again, Your Honor. Raymond Cook for the people. And Alex Warren Green on behalf of the government. Government, can you stand and state your name?
Michael Gaddy, Assistant Public Defender.
The court, having gone through all of the evidence in this case, having heard all of the testimony in this case, I'll start out with count one because it was sort of raised by the people, not necessarily raised by the defense, where there's a taking away of the very fact that there was no money which was taken. I don't think there's any bearing on the armed robbery charge. In looking at what I could see, and the court does believe there was and would have been a larceny and maybe uncompleted at some point, but the court does believe that the people have shown enough for the offense of armed robbery to occur. That goes with as to all of the offenses. But let me address one thing, and that is primarily the identification of the defendant. And the court did take to heart the defense's argument regarding the regarding his identification. What is very clear from the detective's testimony, he didn't hesitate one bit to say that it was Kyle Zimmerman. He also, from this court standpoint, gave enough sort of life context to his ability to identify him without going into the specifics. There are numerous points at which he's seen him. He's known him for 45 years. He also indicates that it's a few months before this that he saw him. And also, again, and the court isn't taking into account that he may have been in the jail there, but he made reference to the fact that he's seen them when there was discussion regarding sunglasses or the wearing of glasses as opposed to not wearing glasses. So the court found his testimony extremely credible, particularly with reference to the identification. And then also with that identification, the context by which the detective is even notified leads you, I think, additionally substantiates his identification, because there are these text messages that Mr. William Zimmerman had testified to, and a number of things that in this court's mind are going on there. For the purposes of preliminary examination, I think that a 99.5% identification of this Joe person who is in Exhibit 2 is enough for the people to show the second prong that it was this defendant that committed the offenses. The people have also shown, so the people have shown the armed robbery. There was the stipulation that the defendant would be a prohibited person. And so the people have sustained their burden as count 2. What is clear also with reference to the firearm, yes, there may be a question of its nature that the people might have to overcome, but it may be a question of fact as to whether or not it constitutes a firearm or the statute is raised by the defense. But this court believes that's a question of fact to be decided by the finder of fact. When I saw the clip, there is no doubt in my mind that what I saw and what I think that to be would be a firearm capable of inflicting harm upon another person. So I'll leave that to the trial court to decide. There is also then the felonious assault charge, which I think that they have shown regarding certainly Ms. Hoff. Also, given where this had occurred, the nature of what the defendant in this case was attempting to do, the court will add the bank robbery charge, and would also, with the bank robbery being the predicate felony, but also I guess the armed robbery could be the predicate felony. We'll add the bank robbery, I think, yes, the armed robbery is already included in count 3. I will add count 6 of felony firearm with the predicate offense being the bank robbery charge. So therefore, for those reasons and taking into account all of the testimony, the court would find the defendant over to stand trial on all 6 charges.
The information waiving reading and statement.
And then having Wait for reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pretrial in this matter will be set
August 13th at 1:30 with Judge Slay.
August 13, 2026, 1:30 before Judge Slay. Bond will continue.
Your Honor, I have a copy of the amended information that has been signed.
Oh, wonderful. I messed this part up. You signed it.
Yes.
Okay, thank you. Bond will continue. Thank you.
Thank you.
Yeah. Paperwork straight. Yep. Zero 31. Okay. This stays, this is back. Yeah. And that's it. Yeah. I got my 1 o'clock and it's about 1:09. Court's going to take a brief recess. I'll come back and start my 1 o'clock docket. Court staying in recess.
Ross.